Perfect submission. Các sản phẩm để cho bạn trẻ dùng bản lắm.
For hearing item number 1.
Lordship, before I begin.
Yes. Affidavits. Affidavits. Yes.
Which? Lordship, the same will be treated as a part of the opinion. Lordship, may I begin? Lordship, before I go to the merit of the case, I just want to point out that by order dated
You are for the response number
1, Lordship.
1 and you are the read petitioner.
Yes, I agree with that. Lordship, by order dated 26/10/2016, on my prayer, I was allowed to withdraw the challenge to the rules.
Yes.
And Lordship, any
That we have seen.
yes, Lordship, because there was an argument that no challenge remains on the order of redesignation. But it is clearly mentioned in the last part, Lordship, that whether would like to confine his challenge to the interest seniority position between the petitioner and the respondent number 8,
Correct. Correct.
as well as the order of redesignation. Lordship, that has been. And Lordship, in the meantime, since there was some typing error, I have finally the petition and then the same has been. Lordship, yesterday my learned friend has expressed on the point that the appointment of respondent number 8, or rather the appellant, respondent 8 in the writ petition was a mistake. That is, there is no mistake as such, because Lordship, since the creation of the post in 1990, the first appointment was made to one Mr. Jonathan. He was also appointed by the Works and Housing Department. He continued as assistant architect in the department. He was posted to the town planning department. He remained as such till he was regularized by way of absorption as ADB. Lordship, on observation, his date of seniority in the cadre was 1/3/1997. It was the day with effect from which he was observed in the department. And the same was done in the case of the present appellant. In 2000, when she was appointed by the Works and Housing Department. Lordship, till date, there is no order observing the appellant as ATB or into the cadre of the town planning department. The examination she passed was for the post of assistant architect in 2002. Then 2000, and as such, she was appointed. Judgment, which is included.
Yes, please.
From para 18, para
18.
yes, 18 of the judgment.
Yes.
From the officer, it is clear, it is fairly clear that the petitioner in the respondent number 8 were born into two different cadres under two different.
Just a minute. Just a minute. About this.
Oh, yes. Appeal memo,
First.
first part.
Before.
Yes.
You are at page 14, para 18.
Para 18 of the judgment.
Page 14.
Yes,
Internal page 14. I think.
yes. Yes, yes, I'm sorry. From the officer, it is further clear that the petitioner in the respondent number 8 were born in two different cadres under two different departments and on two different dates. Therefore, here is university seniority cannot be considered until and unless one of them is brought into the other service / cadre by follow due process of law in as much as Rule 16 of the rules of 2004 provides that those persons who are directly recruited into the service, their seniority shall be fixed as per merit list prepared by the commission. From the rule of seniority in both the service rule as engineering rules 97 and 2004 rules governing the service conditions of the respondent number 8 in the petitioner respectively, it can be conclusively held that the seniority between the petitioner and the respondent number 8 cannot be determined as both of them were selected and appointed by the commission by different selection process and do not belong to the same merit list. In view of the opposite factual matrix, settled position of law, even if this court holds that the respondent 8 was born into the cadre under service rules of 2004, either by virtue of notification dated 29/2006, this is the order of rate designation, or by virtue of the framing of the rules of 2004, which came into effect from 39/2008, the respondent number 8 cannot be granted seniority over a petitioner who was already working in the department by virtue of his due selection by NBFC. That was in 2004. 21 in the letter part, she continued the fifth line.
She continued.
She continued under the control of the parent department, which is clearly reflected from the plan of study leave and her joining report before the parent department after returning from study leave. The state respondents are at liberty to regularize her service or observe her in the town and country planning department in exigency of service. However, same need to be borne in mind, done by following the due process of law, which has not been done by the respondent authority. However, the intent is clear, is that the scenario from the notification dated 29/2006, in any event, the petitioner cannot be This was the correction that was made. This sentence.
Yes.
This sentence was not corrected. In any event, the petitioner cannot be treated as senior to the respondent and eight.
It should be respondent number, it cannot be treated to
Yes, Lordship, it has been corrected.
Yes.
Therefore, without interfering with the communication dated 29/2006, it is held that the respondent number 8 cannot be treated as senior to the petitioner here when the petitioner entered into service on 19/3/2004 and the respondent number 8 was born into the service on 29/2006. Judgment. Therefore, Lordship, I was saying, as I was saying, the mistake that was alleged to have been committed, no mistake has ever been done. Because for the very inception, when the post was created, only two regular appointments has been made so far. That is one, Mr. Jonathan, who is the present director of the urban development. He was appointed as assistant architect in 1991, and in 1997 he was observed as AG. Thereafter, during the vacancy also, when Jonathan was observed as ATB and the post of AA was lying vacant, there was some stopgap arrangement by the Works and Housing Department. And one Nasangwati was appointed on contract basis, and he continued till the post was filled up by the present appellate in 2000. So all those appointments and extension orders were granted by the Works and Housing Department. And this to say that it was always been held as a career post of the Works and Housing Department. Therefore, Lordship, the appellant and the writ petitioner, the respondent, belong to two different types. One belong to the Works and Housing Department, and I belong to the Town and Country Planning Department. In fact, the respondent, having not been observed in the department, should be, in fact, please with a date of 29/2006, where she has been indicted by way of the great designation. Otherwise, our challenge was that redesignation should not be allowed. But we consider to that effect. That one, if she is made junior to me, I have no other. That was the reason why we threw the challenge to the rules.
I'd request that if somebody from the outside comes to the court, come in proper uniform or proper dress, not in t-shirt and half shirt. Yes, there is no restriction in watching the proceedings, but don't come in this dress. This is a very formal procedure going on.
Also, may I get your worship's to page 304 of the
Memo.
memo.
Yes. 304.
304 is the appointment order of the first incumbent of the, in the post of assistant architect.
That was the first incumbent
Yes,
before the appellant,
yes.
who was inducted after creation of the post in 1991.
Yes.
Yes.
Lordship, clear copy is seen at page 46 of the punch.
Okay, type
But,
punch.
yes.
It doesn't matter.
At page 46.
Hmm.
This is the same. Very good.
Yes.
Having been selected by the Nagaland Public Service Commission, the Governor of Nagaland is pleased to appoint Sri A. Chinitong Lotha to the post of Assistant Architect, Class 1 KZ, under the Nagaland Public Works Department, temporarily in the CLB of Service Sites, plus annual Service Sites, with effect from 16/12/19. He shall be on probation for 2 years during the period of Service Sites. The service rendered in the interest of public service, Sri Chinitong is posted as Assistant Architect under Chief Town Planner, Nagaland. This is the initial appointment of Mr. General. Lordship, now I would like to compare this appointment order with the appointment order of the appellant.
Page.
Look, in the type copy, it's at page number 8.
And the memo of appeal.
It's at page 106, Lord. May I read this also, Lord?
Yes.
Having been selected by the Nagaland Public Service Commission, the Governor of Nagaland is pleased to appoint Srimati Tanjana Latichu to the post of Assistant Architect Class 1 PZ under Nagaland Public.
This is the appellant.
Yes, Lordship. This is order dated 17 January 2000. The post of Assistant Architect Class 1 Gazette under Nagaland Public Works Department, Lordship. This is about temporarily in the scale P of such and such and such and such, Lordship. And for in the interest of public service, Srimati Tanjana Latichu is posted as Assistant Architect in the office of the Chief Town Planner. Lordship, if we compare these two appointment orders, not an either has mentioned. Everything is the same.
Same.
Yes. And this is issued.
This is also issued by the Housing and Works and
Yes,
Housing.
at the top also Governor of Nagaland Works and Housing Department. Here also in 106 also Governor of Nagaland Works and Housing Department.
Correct.
And this is signed by the Secretary to the Governor of Nagaland. And both same. Endorsements are also same. All the copies are. In fact, endorsement can import the orders.
Yes.
One is 9, 2000, the order of the appellant, it is 9. It has been endorsed with the senior architect. PWD now. Now, what the appointment orders are saying? Yes. In the case of the first incumbent,
Yes.
he was just a holder of a bachelor degree in architecture. Initially, when he was appointed,
He was.
holding a degree of Bachelor of Art,
This is
Architecture,
architecture, okay,
without
masters.
the master's degree. But in the meantime, he also obtained a URB. And where the next order at 305. 305. 304 is the initial appointment order.
Yes,
305 is a notification issued by the Planning and Coordination Department.
what is this?
This is the order of absorption of the first incumbent. May I read, Lordship?
Yeah.
The Governor of Nagaland is pleased to order regular absorption of the services of Sri Chimithang Lotha, Assistant Architect, to the post of Assistant Town Planner in the Urban Development Department in the scale B of such and such, plus other time to time, with effect from 1/3/97. These issues with the approval of the BNR department issued such and such, Nagaland Public Service Commission such and such, the approval of the cabinet during the such and such, and wait right such and such. So in the case of Chindisan,
Yes,
on obtaining the degree, he was observed as ETB, assistant town planner, which has never been done so far in the case of the appellant. Was draft rules of 1991 was enforced. But Lordship, I would just like to bring the Lordship attention to the copy that I just said.
which copy?
Lordship, this is an affidavit in reply.
Okay,
Right.
your affidavit. Okay.
Yes. Okay.
Which one?
Lordship, affidavit in reply by the petitioner against the affidavit in opposition filed by the respondent 2, 3, and 4. The thicker one. Lordship.
Yes,
Lordship, let me give you, Lordship, the page 31. I'm referring to a judgment by this honorable court.
page 31.
Yes, Lord. In fact, it begins from page 27, annexure 2. Incidentally, in this case also, the appellant was a party respondent. But just on the point that the draft rules of 91 was in operation, it was not. Paragraph 3 of the judgment. Page 31. Yes, Lord. Page 31, paragraph 3 of the judgment.
Paragraph 3.
Yes, Lord. Your Lines, Lordship, may I read? At the outset, we may report as informed by both the council appearing for the respective parties that the draft rules on which the reliance is placed by the learned single judge has not been notified nor have been come into effect till today. Therefore, the argument that the rules of 91 was in operation is like this is 2003. The judgment,
11/9/2003.
yes, 11/9/2003, and it was the submission of all the parties at the time of the hearing that the rules has not come into effect. It was neither notified nor this also relates to the same department lawsuit. The subject matter involved in this case, involved in this case is my friend has taken your lordship to let me know where the government took the decision to give retrospective seniority to that. And I have to go back to that. Page 21, beginning from 213. This is
Of the
just a-
memo of appeal.
Yes, memo.
Yes, please.
Worship 34, 213 is just a covering letter. This is the response to my RBI application.
Yes.
Worship, the next page. The matter has been examined by the UN department and we agree to the proposal for redesignation of assistant architect post to assistant town planner caterer as proposed. There was a proposal, and it was the BNA department has agreed to that. We should, the next page. Starting from,
215.
yes, 215. Fourth parallel, the bit, starting BNER. It was 40.
PNA, yes.
BNER have concurred vice sergeant for redesignation of the post of assistant architect as proposed by the department. We have not, but this is important, we have not concurred for any particular incumbent nor seniority as per the draft, which we mislead. For fixation of seniority of the employees, the appointment authorities are competent and matter need not be referred to PNR unless we set our specific views. This is in 2007. The handwriting part, the department is operating at this.
Yes.
The department is operating the service rules. In the light of the office memorandum on seniority, the department may first examine the matter and apply their mind to see whether the person selected as ADB through NPSC is superior to the one who could not be selected as ADB and the same examination conducted by the NPSC. Worship, we have saying that both the appellant and the respondent one appeared for the examination of the assistant town planner in 2003. And I was successful in the appealing for the same thing. This is view of the BNR department. In the next picture, the view of the Nagaland Public Service Commission. At the bottom, look at the type copy.
Yes. Just a minute. Yesterday you had made a submission that this will not have any relevancy. And you have also gone to the extent that in the event, we had not opted to sit in this examination, what would have happened? But that's a different context. But why did you opt to sit in the examination? You are not aware, you are not confident about your position and seniority.
I got him out of the Mrs. He was post promotion. Your worship, to say that the draft would be not modified is.
No, we are not on that. We are not on
Because
that. We are not on that. We are on the on your conduct
Yes.
that you chose to compete with maybe the writ petitioner or anybody else because the present post which you were holding, you found that this will not have any give you any benefit of your seniority. So you wanted to come through the proper process by the NPSC,
Most of the promotion.
where you could not be successful.
Yes, madam. That's what I agree. No, what I'm saying is.
Okay, we'll come back to you. Yes.
216.
216. Next
Same
page.
as
Yes.
your worship has already.
Next.
Bottom,
Yes.
bottom part,
Bottom part. Yes.
216. This is the Nagaland Public Service Commission view on the merit.
Yes.
The posts of AA and ATP are no doubt recruited through Nagaland Public Service Commission. But as a matter of procedure, fixation of seniority is a subject which is entirely within the authority of the department. Such dispute should therefore be settled by the department without referring to the Nagaland Public Service Commission or the BNR. Now the final decision of the BNR is on.
Where it is?
Next page, 270.
Yes.
At the top logic.
Mm.
This is OMCL in here. The matter has been examined in we offer our observation as under. One, yes, the department is operating the service rules in the light of the OMs on seniority. Department may first examine the matter and apply their mind to see whether the person selected.
Yes, this has already been said earlier.
Yes, Lordship. But
Again,
this is the final.
reiteration. Again, reiteration. Okay, thereafter,
Yes,
where is the decision?
Lordship, this is it. Now, the BNR are saying that it has.
No, no, here only the reference has been, the department is operating. This is by which the matter has been examined and we offer our observation. Please read, the department is operating service within the right of the department first examine the matter and apply the matter to see whether the person is seen to one who could not be sure. Where is the decision thereafter?
Lordship, this is the one that we've already sent. This is Ben written one which we sent in 215. This is same as the handwriting one. 215. So the decision was given by the DMA. But I don't know how, but somehow the matter dragged on. And ultimately, my learned friend has shown the other part of the extract. The decision was taken to reverse the seniority decision between me and yeah, in 2000. Was it a question? There was another question instead of that. I approached the court. Question in 2006, the redesignation was done. 2006. But after redesignation, there was no change in the status of our seniority. I remained senior. There were two seniority lists in between 2007 to 2009. In all these two seniority lists, I remain above the appellate.
When was the seniority list published?
One in 2007 is, and one another one in 2009. You know, for the seniority lists,
You were held to be senior.
yes. But by the impugn notification, the impugn seniority list, it was reversed. And that was the time when cause of action arose. Otherwise, till 2010, there was no cause of action. Nothing to agitate about. Because I maintained my seniority above the appellant, and therefore there was no cause of action. But when the seniority list was reversed in 2010, I had to approach this court. And that's how it was in 2010, after the final publication of the seniority list, I approached this court. So the question of today as a legislation has never happened. In fact, there was no cause of action for it. Because even after the designation, the position remained me as the senior. In 2010. May I take your worship to 187? This is the
One,
87 of the appeal memo. 187. This is the order of notification whereby the resignation was done.
yes.
This is 20 September 2006.
Yes.
The governor of Nagaland is pleased to redesignate the existing post of assistant architect to assistant town planner under the establishment of the urban development department, class 1 president in the SLB of science, right? Recently held by Srimati Temtirala Kitu with immediate effect.
This is by which department?
This is by the planning and coordination department.
Yes.
This was issued in pursuance where approval of the BNER department, Lordship, we have just sent at page 214,
Yes,
where the BNER department had approved for the redesignation of the post. Lordship, the work with immediate effect will be made. Lordship, it is not an order whereby retrospective effect has been given. It is a prospective in nature, and therefore the appellant cannot be claim for any retrospective severity on the basis of this.
yes,
For sure. The order of redesignation was passed at the behest of the. I'll show you how this has come into. The appellant approached the town planning department on two occasions by way of representation. Let's see the first representation.
yes,
That is a 313 of the appellant.
yes,
It's a short application to the chief town planner, urban development department. Subject application for appointment to the post of assistant town planner.
yes,
It is understood that there is a possible vacancy for the post of assistant town planner coming up in the office. So, as a result of the subordination of in service of civil sergeant type, assistant town planner is an opportunity. With due respect, I have the honor to state that I have been employed in this department since January as assistant head class one physical having been selected by the National Service Commission. And that's having been sponsored by the government. The order number sergeant says, 21/7/2030 includes. I have also successfully completed the master's degree in urban planning with gold medal. Therefore, I would like to offer myself as a candidate for the same. I would be much obliged if you would kindly consider my candidature for the same post, and for which act of kindness I shall ever remain grateful. Also, she accepted the appointment of 2000. I wish she was appointed as she had made no complaint whatsoever. She accepted it all along, knowing that she is being appointed in a different department by a different authority. And she was on normal posting and deployment. But she accepted it, no complaints whatsoever. And she prayed for appointment as ADB, Assistant Town Plan. In the country. Worship will kindly see the contact of her. She was well aware that she was from a different category. That's why she sought for appointment. And then
no, this representation was addressed to whom?
this addressed to the chief town planner.
Of which department?
Worship,
Chief Town Planner of UDD.
chief town planner, urban development. This is the present one. Otherwise, earlier it was headed by the chief town planner before bifurcation. And then it became under the urban development. In 2006. Nomenclature was changed. Okay, another one which is 317.
Yes,
That is the genesis of the re-feasibility. In
317,
yes, 317.
please.
This is the application. In this, in fact, she prayed for absorption also. Lordship, we all know what absorption entails.
Yes.
Lordship, skip of from 4 I will tell you. Meanwhile, I was selected to implement the proposal of assistant agri class 1 unit in this seat. Thereafter, I was sponsored by the government. We have just said that. Shortly after this, during the course of ATP Singapore fell vacant due to retirement of 3%, I submitted my application dated 18 March 2002, which we have already seen. The appointment against the three persons was already regularized through MDC, which has identical scale of pay as ATP. Moreover, I was a senior most serving colleague. In this connection, the next year, as earlier, case of Sri Kimetang Lota may be cited. This is the same one which we have already seen.
Earlier incumbent.
Yes, the first incumbent, in fact, who was initially first recruited through in this and appointed as assistant agri in the department in February. And later, after obtaining MURP, degree was observed. In the present case, no such thing has happened to us yet. When a vacancy came up. However, in the case, the government did not take up the matter. Instead, in this connection, the undersigned has submitted an application 8/3/2003 requesting for Lordship, this is her prayer, for absorption as ADB against the said post. In another application dated 8 July 2003, pointing out that the appointment of another person candidate to the advertised post of ADB already been arised. The department forwarded my case. Such effect is 16 July. However, still no action was taken to appoint the nominated as per the earlier precedent. Rather, a fresh recruit was appointed against the seat post in 2004. That is me, Lord. I was appointed. While the undersigned, despite being senior was available in possessing requisite qualification of MBA, after being sponsored, night of particular case absorbed as PDB against the vacancy as per earlier precedent, creating serious. Why her case was not proceeded in 2002 and 3?
Yes.
The affidavit I submitted earlier.
Which one?
The one we have seen earlier.
2, 3, and 4.
Yes, this same one.
2, 3, and 4.
Yes. Reply to the to 2, 3, and 4.
That will be the website. I just.
In 2003 and 4, 2 and 3, there was a proposal, no doubt, for appointment of the appellant to the post of ADB, assistant town plan. But something came up during that. What happened, Lordship, was during that time, the Nagaland Public Works Department did not agree to give up the post. This is already shown in the extract of the RTR. Can you see?
Page.
Go straight to 23, the type of law. refer to the following periods. Got it? According to DNA memorandum such and such, clause 8, any contract of owner is made. This is not. In the present case,
Yes.
if we go for arrangement of those as approved by the honorable minister planning, there is some technical problem arises. Suppose we cannot move the Nagaland Public Service Commission clearance and send the position to the industry for the post of assistant architect from our department, as the post belongs to Works and Housing Department. That is with regard to the post of assistant. Next page, 24. However, while examining, the post of assistant architect is not under the urban development and will have to be done through the Works and Housing Department. At the same time, there is a High Court case for appointment of ADP post wherein ADP, OCA, fact and present assistant architect are involved. Those who have seen the judgment. In lawsuit 25, yeah.
Yes.
Last time.
In this regard,
Yes, in this regard. As noted on the previous correspondence note by Secretary Planning, we are waiting and waiting the reply of the PWD department. But till now, no reply slash clearance is coming from PWD department. In the light of this, as discussed with Secretary Planning, the matter was discussed verbally between Secretary Planning and Secretary PWD. And says that the PWD is not in a position to part the post of assistant architect through urban development. So if it is the case, we are of no use to pursue them again. Next one, Lordship. Significant report. However, the present department, that is the Works and Housing Department, who is the appointing authority for assistant architect,
where are you reading?
at the middle, at the page 26, Lordship.
The filling up of the,
No,
that
yes,
part.
the filling up of ATV Zenabuto was already approved by Minister Planning. However, the present department, the parent department, that is the Works and Housing Department, is the appointing authority for assistant architect, engineer of town planning division, is reluctant to part the post. This has been confirmed with the Secretary of Works and Housing over form by the understand. So that was the hurdle. Why should not be appointed? Had this been successful, they would have been no case. This present case would not come. But unfortunately, there was a hurdle. The BTP department, Works and Housing Department, refused to part with the post of assistant architect. And therefore, the arrangement that, the internal arrangement that was made did not succeed. And therefore, the post of ATP was advertised in 2004. I was selected. And secondly, in the selection process, I didn't feel that bad. Article should be one article to five. Government. This is page 275. This is While on behalf of the respondents, 5 and 6. Just one paragraph left with that. Page 277. Yeah. Yeah, that's it.
Yes,
That with regard to this paragraph of 11 of the writ petition, the deponent states that the post of assistant architect was requisitioned to the Nagaland Public Service Commission through Works and Audit Department, and accordingly, the appointment order of respondent number 8 was issued. As the caterer, this is important. As the caterer, management and technical staff in urban development as well town planning department rested with the Works and Housing Department. So they are admitting that the post of assistant architect belongs to the Works and Housing Department.
please read again.
Yes. That with regard to para 11 of the writ petition, the deponent states that the post of assistant architect was requisitioned to the Nagaland Public Service Commission through Works and Housing Department, and accordingly appointment order of respondent 8 was issued by notification dated Sergeant Site, number Sergeant Site, dated 17/1/2000. As the caterer management and of technical staff in urban development, as well town planning department, rested with the Works and Housing Department.
However, what is the last line?
However, issuing appointment order does not mean that the Works and Housing Department acquires right to take over the post created by the. You know what I'm trying to say by that line. Once they admit to the fact that they are the caterer management.
Don't you think that both the sentences are contradictory?
Yes,
Firstly, they say that it is works and housing, everything has been taken over.
yes,
And the recruitment though done by the NPSC, it is on a requisition made by the works and housing.
true, Lord.
But last line, it
Last
says
line.
the appointing order will not give them any right as it was created by the urban
They are
development.
contradicting themselves, Lordship.
Hmm?
They are contradicting themselves.
Yes.
Lordship, to that
So
effect,
will it benefit you?
Lordship,
Will this contradiction benefit you?
Lordship, minus the last part,
No, that is it, minus the last part, but
Yes.
last part is there in the
but
affidavit.
this also does not hold water, Lordship. The last part also. How can you see one thing in one sentence and the immediate next sentence they say something different? Lordship,
No, was the government supporting you or not in the proceedings?
during the, in the writ
During
proceeding,
the writ proceedings.
Lordship, I was the lone star. I was alone.
Now you are with the government.
I don't know with what she has. She has not been five.
She has not opened her cards.
Lordship.
She has hold her cards to her He has not opened the cards as yet. Yes, madam, where are you? This side or that side? No, no, we know. Where is your stand? You're sitting this side, your mind is that side or what? Appellant.
That's what I said.
Our sitting beside you is not, is deceptive.
Lordship,
Our sitting beside you is deceptive. It's only for moral support, nothing else.
Apart from the moral support, she's giving some physical support as well.
Okay,
Lordship, we've seen the order of amalgamation. Yesterday, my Leonard Flynn has shown Lordship supported. That is the order of amalgamation. But if you look at the drafted. There was another order. One memorandum was issued. I will take your worship. That is at 184.
184. Yes,
This is issued by the Department of Personal and Administrative Reform. Memorandum.
89, 25th.
Yes, 25th May 1989. Amalgamation of engineering wings attached to various departments. Lordship, before I read it, there was some doubts and misgivings by the various departments who had engineering wings. Therefore, this particular has to be issued. The government-wide notification dated such and such 6/12/88 had ordered amalgamation of all engineering wings attached to various departments except NST, geology, mining, and agriculture. With the Works and Housing Department, some departments have expressed dissatisfaction over the present arrangement, which had come into force from 1/4/89. Therefore, the matter had been reviewed by the government and has now been decided that the above decision shall stand subject to the following conditions. Condition 1 is cater management and technical supervision will be under the Works and Housing Department. In tune with this, they have replied in the affidavit. Okay, with that, at that second line of it, this is issued by the operating authority. Line with this, they have responded to their affidavit. That the cattle management and technical supervision will be under their Works and Housing. And the second one is budget provisions. Administrative control will rest with the department personnel. So
Yes.
and also, unfortunately, even after this original another office memorandum was
Date
next page.
185.
Yes. This is in fact, of course, by the Works and Housing Department.
3rd April.
Yes, Lordship, 3rd April of 90. I will read the second paragraph. It has been brought to the notice of the government that some of the departments having engineering wings, instead of complying with the government policy, are raising various issues which are not relevant and causing delay in the implementation of the policy. For instance, some of the engineering personnel on deputation to other departments from Works and Housing Department are not released by the user department, even though transfer posting orders has been issued by the Works and Housing Department. In some cases, deputation has been extended or regularized by borrowing department, even without consulting the parent department, that is the Works and Housing Department. Some of the departments, like Lordship Industry, Rural Development, and Town Planning, my department was at fault, the culprits. We did not want to go back. So this was issue. We did the last part explain why it was issue.
Yes.
After 2007, when the BNA had given the decision on the decision, in a better track. And in fact, in 2009, the decision was taken to reverse to 2009 and that the decision was taken to reverse the seniority decision. Back up of me and during the study by the BNA department,
The change was in 2009 or 10? 10, I think.
it was in 10, but
10.
the
9, you said that 2007, 2009, both the seniority list you were held to be
yes,
senior.
I was, but
The reversal came in 2010, followed by the writ petition.
But the decision to reverse that was taken by the BNA department, during 2008-9. But Lordship, my management has shown the extract study, whereby the BNA department had taken a consideration, that is the scale of pay. Okay. That issue has already been settled by the phase, whereby 4 factors has to be examined before 2 posts are equated. Now, out of the 4 factors, the BNR department in the instant case has taken the least important one, that is the scale of pay.
Which is the declaration? Which paragraph?
Maybe that otherwise.
that is part of the, it is part of my affidavit. I raised that question. Because on the RTI extract, they have already noted the scalar pair. Go back to that.
Please give us this paragraphs
Yes.
of the, that part you will take care of later. So as the paragraph in the citation.
The factors that have to be considered is that nature of works and duties.
Which paragraph?
Just reading the own. And responsibilities and powers and minimum qualification in scalar. So scalar is the least important. Not that I'm not saying that it should not be affected, but it is the least important. Worship in the Eastern case, for the two posts, the two posts, the post of assistant town planner, or the post of assistant town planner, required here, besides being a degree in architecture, is a need to have in UI. But for the post of assistant architect, mere degree is enough. For the post of assistant architect, it's just degree in architecture. For the examination, the syllabus is different. The appointment to the post of ADB and assistant architect. For duties and function relates to, for the ADB, it's master plan. Master plan. Whereas for assistant architect, it's just architectural instead of design. Therefore, the two cannot be equated. The fact that
Okay.
the two posts cannot be equated. The fact remains that she was never appointed to the post of assistant town. She was appointed to the post of assistant architect after passing the examination for assistant architect. In fact, she tried assistant town planner, but she failed.
That was in 2023, 20,
Oh,
2004.
2004. Exam was conducted in 2003. In fact, appointment notice was issued.
Where you were appointed.
Yes. It was the only time she tried to become a ATV through selection process, she failed. She managed to pass it. She left assistant.
Okay, you conclude. You said half an hour, you took more than an hour,
I said
half an hour.
for half an hour or more than that. Or,
Or more will be very vague.
yes, like it's a vague term, but then still.
You conclude. We have to hear Mr. Jamir also.
Parents have to do
17 of
of the judgment.
judgment. This, Oop Singh, judgment which you just referred. Sub-Inspector
Yes, service center.
Ruplal. 17. Yes.
These four factors are.
Yes.
The nature and duties of a post, responsibilities and powers exercised by the official holding the post, the extent of territorial or other charge, held or responsibilities discharged, minimum qualifications legally prescribed, and the salary of the post. This is important factor was given in the presentation. None of the other three were examined by the BNER department, while retrospective seniority to the
In fact, here in paragraph 17, after noting down the four factors, it has been laid down that even if the fourth factor is not met, then also it may not be material. So the scale of pay is not a very material factor. What is material is the nature of the duties, qualification, and responsibilities. Those you have submitted was not at all discussed in coming to the interview decision, which is a subject matter of challenge in the application.
According to the 2004 rules, there are only two methods allowed for the rules to become assistant town planner.
Okay.
Rule 5.
Where are you reading?
Rule 5.
Rules. Where are those rules? Part of the memo appeal. Two 40.
It's 80. Starts with
88.
no, it's
80.
80.
Yes. Rule
Conflict of recruitment.
There are rule 5.
Yes, Lord. It says by direct recruitment and promotion from lower grades.
Which is the page, it's not properly.
83 Lord.
Mandalay. One five. Mandalay B.
Mm.
Yes. Page 15. 50. B you have said 50. Mandalay.
It's 50. Under B is inclusive.
Yes.
Under A is something.
No, you are referring to which rules?
Down in country.
2004 rules.
Yes.
That is in Mandalay. Page 50. Yes, yes. You had referred to this yesterday. It was notified in 2008.
Yes, Lord. What I'm trying to say is that
Yes.
what I'm trying to say is that there are only two methods allowed by the rules to become ATB.
Please read 5.
Yes.
Method of recruitment.
Methods of recruitment. One is recruitment of various grades of service after the commencement of these rules shall be regulated as per terms and conditions stipulated.
Yes.
Provided direct recruitment by
Yes.
Schedule 2 of the rules.
Yes. Yes.
Rule number 4 is in addition to assistant town planner.
Yes.
Column 8.
Yes.
Column 8 says 50% for direct recruitment, 50% by promotion from planning assistant, staffman. So we are having the requisite qualification for the post with at least 7 years of year experience so there are no other methods or means to hold the post of assistant town planner except the two uh, which by which I was appointed and by way of therefore the redesignation by way of each redesignation the respondent appellate has become the ADP is unknown to the rule.
But this designation was done in 2006. These rules came into operation in the year 2008. So at that time, when the designation was done in 2006, what were the rules which were in operation?
Lordship,
At the time when the
no rule was there.
so your submission that with regard to the post of assistant town planner, there are two methods which are prescribed by the rules. One is direct recruitment 50%, one is promotion 50%. But the rules came into effect in 2008. You may be very correct in contending that a redesignation is not envisaged by the rules. Redesignation as assistant town planner is not is not stipulated by the rules, cannot be done. But the effectiveness of the rule came in 2008. And its redesignation was effected in 2006.
Yes.
So if there was no rules at that time, can your submission be
The effect of redesignation was only made effective from 2010 when the seniority was was although the redesignation was done as early as 2006,
yes?
it was not given effect to Lordship until the seniority position of the appellant and me were interchanged.
Where is that 2010?
2010 is the final seniority list, which is which in fact has been partially set aside by
2010 seniority list.
against that I came, Lordship. Because till 2010,
But that's a different aspect. Uh, whether seniority was conferred upon him or not, that's a different aspect. It was not conferred all this time, it was conferred in 2010. You are aggrieved, you came before this court.
yes,
But the redesignation may not be directly connected with the seniority aspect. Redesignation is redesignation.
yes,
And
that's what
in absence of any rules, to the contrary, you can have other grounds of challenge, but to contend that it is beyond the rules or not prescribed by the rules, that we have to check from the effectiveness and the rule.
2006 when the redesignation was done, I was not affected. And it continued like that. Because the order of the redesignation says
No, that aspect we are examining.
we,
Not
the impression was
that aspect we are considering, but the aspect which you just tried to raise, that the redesignation itself is beyond the rules, perhaps this way difficult to accept because there were no rules at that time. But seniority aspect you are
Yes.
You're absolutely at your liberty to assail the seniority aspect.
Okay.
That you
Because
have already said. That
It
you have
was
already.
assumed, since the order of, was implemented before, no retrospective seniority will be granted today. Therefore, we made like that. And in fact, in the tentative seniority list of the 2007 and 2009, I was ranked senior to the appellate. And only in 2010, it was changed. Reversed.
Yes.
Therefore, worship, considering all aspects of the matter, right from the inception, with the post of assistant executive president. Later, all appointment and posting were done by the person housing department, including the rate of in the case of the rate.
Yes.
In fact, on appointment, after appointment, she sought permission from the person to go for further studies. On returning from her studies, she joined her parent. These are all reported in the judgment of the city.
Yes.
The law on the question of retrospective severity, granting of retrospective.
Sure.
Worship is 2000 Continental Forest Rangers.
Citation.
This is 2006 then SSC. That just the gist of it is that a person seniority cannot be granted to a person who is not born in.
Citation.
2006 10 SSC 346.
346. Name.
Uttaranchal Forest Rangers Association.
Uttaranchal.
Uttaranchal. Therefore, it is the case of it. The date to 29 2006 as allowed by the report should stand and there is no need for difference of this.
You have not challenged the redesignation.
We have challenged Robert. Okay. Challenge. We have challenge. But, report had not different, just how that I should. Withdrawn, I'm saying the lawsuit is great. Challenge to be withdrawn. He did 26/10/2016. This is the day through the challenge to the rules. And Lordship, I've read it in the very beginning outside also, that after hearing the matter at length, Mr. S. Tata, Learned Senior Counsel for the petition, submits that he is not pressing the challenge made to the rules of 2004 and would like to confine his challenge to the intercede seniority position between the petitioner and the respondent number 8, as well as the order redesignating the post of assistant architect as assistant town planner. If that be so, this matter would be required to be heard by the learned standard judge with the consent of the learned counsel
You're
of the
correct,
parties.
you're correct.
officially.
Only the virus part of challenge we have withdrawn.
Yes.
Therefore, it came before the division bench to the single bench.
So therefore, we have not confirmed the challenge.
Yes, state government.
And your worship,
Now, in the writ petition, you had filed affidavit.
yes, your worship.
You're not required to file affidavit in a writ appeal. It's a continuation of the proceedings. No fresh pleadings, unless something new has been set out in the memo of appeal. Otherwise, you go by the pleadings which were for the learned single judge. What was your stand there?
What's that there is that, use of,
No. Say you had taken a conscious decision to bring all engineering personnel under one department, namely works and housing. That was the decision which was encompassing all the departments in the state of Nagaland. Thereafter, one post of assistant architect happened to be created so far as town and country planning department is concerned. So will that post remain to be post remain under the town and country planning department, or will it automatically come to the works and housing?
it's under the top planning, your worship. The creation was,
So how do you reconcile it with your conscious decision to have all engineering wings under one department? And what is the exceptional circumstances that only one post of assistant architect will remain in the planning department?
Yes, your worship, if we see the creation of the post, it's very clear that it's under the
244.
your worship, 301, your worship.
Yes.
Yes. I'm directed to refer to letter number such and such on the subject cited above and to complete the sanction of the governor of Nagaland to the creation of one post of assistant architect class 1 gazette under the town planning department. Your worship. But it's not under the goods and housing. If you read that is worship at page 237. At page paragraph 4. At paragraph 4, I clearly stated that with regard to the statement, paragraph 2 of the writ petition, that the following admits that the petitioner was appointed as
assistant architect on contract basis for a certain period. It is implied that the post of assistant architect belonged to the Works and Housing Department. It was a substantive and regular post under the Urban Development Department created after the amalgamation.
Okay. Mr. Senior Jamir, what do you say?
I will be very particular on the timing of my submission, Lordship. I will take only about 20 minutes. Maximum limit I will not cross 12:30. So for us, I'm the respondent number 9. And so far as the role of the association is concerned.
The response number 9 in the writ proceedings, in the writ petition.
I will come to that.
No, no, R9 in the writ petition or in the writ appeal?
Oh, in the writ appeal.
Writ appeal.
Yes.
Okay. You are the association.
Kindly come to.
You are the association.
Yes, yes. Raglan Physical Planners Association. Kindly come to page 341.
341.
Yes, this is by the division bench of this level 4. But before I read out these, I would like to clarify one point, Lordship, with regard to the post of assistant architect creation and the controlling officer, that nitty-gritty point. Urban development, the present, I will just refer to the present name
Yes.
of the department, that is Urban Development Department. It's a multidisciplinary department. It has engineers. At present, there are 4 executive engineers, 13 STOs, assistant engineers, sorry, and 23 junior engineers. These are technical officials.
23 sub junior engineers.
Yes. And they are all posted from PWD department, so-called works in post. Creation of post may be any post. It may be in the urban development department also. Post may be created because lordships are well aware. When a post is created, it cannot be marked for a particular person that this post is created for this person. No. Post creation will be there. Person will come in.
Right.
So there are so many posts which is under urban development department, but the posting are being done. Technical personnel, especially, they are posted from PWD departments. So that is how, at present, there are 4 executive engineers in the urban
Now,
development department.
this personnel, 4 executive engineers, 13 assistant engineers, 23 junior engineers, they are substantively appointed under which department?
PWD department.
Public Works Department.
Yes,
They were
posted. to the
Posted.
urban department.
is it a deputation? No, not a deputation.
No. Yes, so like that, but they are posted. Similarly, assistant architect post was created under urban development department. Earlier it was under a different nomenclature. And the present appellant has been posted there. As my learned friends have already referred to the.
This assistant
appointment
architect
orders.
was created under the UDD, under the Urban Development Department,
Yes.
and posted.
Posted from the PWD department. That is the reason my learned friend has also referred to the appointment order. Initial appointment is done by the Works and Housing Department, PWD department. When she wanted to go for the study leave, permission was sought from the PWD department. That is the career controlling department. And after finishing her post graduation in the MURP, when she returned, training report was submitted not in the Urban Development Department, but in the PWD department. That shows that she is in the appellant is an employee of the PWD department. So many officers are posted. Even the existing employees who are working under urban development department are posted, especially technical personnel are posted. And other posts may be created for the urban
Now,
development department.
what is the difference between the public works department and the works and housing?
Say, works and housing is the government and the PWD department is the,
One of the segment.
yes. Now, under PWD, there are 4 wings. Roads and bridges,
Now, under, we are on the works and housing.
under works and housing, all are under works and housing.
We-
Works and housing is the government and the PWD is the department. One is secretariat, one is directorate. Administrative department is works and housing. These are all under the control of works and housing.
UWD, UDD also, everything is there.
Yes. Under PWD, housing department, UD is not under works and housing, yes. UD is a separate and independent department. But posting are being sent from the PWD department because they are the technical department and who are looking after all the technical departments. Error controlling officer is there.
Sorry.
Now, I was referring, I hope I'm clear on that point also.
Yes.
Page 341.
Yes.
This is order dated 25/20/15, passed in IA 11K of 2015. Passed by the bench of the Honorable Court. Let me refer to the last paragraph only. Having regard to the above and considering the amendments made in the application, where is accepted, Nagaland Physical Planners Association is allowed to intervene in the head of the WPC number 71K of 2010 as intervener, and it will be open for the intervener to file affidavit if so advised. So, in terms pursuant to this order, the association has filed affidavit in the writ petition. Our IA is also not included in the appeal memo, but that is okay. So, accordingly, affidavit has been filed. Kindly come to 331, that is just 10 page before 341. 331. I will
Yes.
refer to only 3 paragraphs. Thereafter, I'll make the submission and I will win up my submission. Page 331. I will refer to only 3 paragraphs.
Yes.
Paragraph 6, 7, and 11. Paragraph 6, Lordships will file at page 336.
Paragraph 6.
Yes. Page 336. I will take on 3 paragraphs. And
Yes.
that will be my case. There. That this development big to state that there has been instances in the department where some vested interested persons totally in contravention and divorced the service rules tried to enter into the department by way of deputation. One of such recent instances was to the post of deputy director. Although there is no provision in the service rule for filling up the post of deputy director on deputation, as the said post is 100% promotion post from the assistant director. One incumbent was brought on deputation for filling up a vacant post of deputy director. Since the said appointment on deputation was met the host rules, the NPPA, that is the present respondent, approached the Honorable Court by filing a writ petition before the Honorable Court, being WPC number 122K of 2014. However, during the pendency of the writ petition, the said incumbent was transferred as principal Government Polytechnic Kohima, and in view of the subsequent development, by an order dated 23/2/2015, the proceeded petition was disposed of as infractions. Therefore, from the past experiences, there is every possibility that if the service rule is not protected in the code of law, there is every likelihood that the authorities may appoint any person at any point by bringing officers into petition and or on redesignation, making the service rule redundant and would adversely affect the promotional avenues of the employees of the department and as such. And such action of the authorities which will prejudice the interests of the association as well as the department. Paragraph 7. It will lay down the path precedent. So we are in the winning.
Yes.
Now, this tribunal big to state that the post of assistant architect was only created in the year 1998 in the Department of Urban Development. This is about the creation of the post. In view of the amalgamation policy, the post of assistant architect was requisitioned by the NPWD, appointed by the NPWD, and posted to the Department of Urban Development. Similarly, the post of executive engineer, subdivision officer, and junior engineers were created in the Department of Urban Development, and the incumbents were posted from the NPWD, that is Nagaland Public Works Department. However, there is no provision in the service code for redesignation or filling of the post of deputy director and deputation. The redesignation of the respondent number 8, that is the present appellant, has been met in violation of the service rules, and the same has been done by the authorities solely to favor her. In the event of dismissing the extended petition, it would amount to legalizing the illegal action resorted to by the state respondents, which has been done in violation of the provisions of service code. And paragraph 11. Page 339. That this tribunal big to state that the long pendency of the writ petition is not only affecting the junior officers in the department in the matters of promotion, but officers in the higher grade in the department are also adversely affected who are answerable to the general public for slow progress of the development activities. In view of the frustration in the lower grade caused due to the stagnancy in the service and promotions being denied, which is the only incentive for a government servant, and because of the long pendency of litigation between the two incumbents, the functioning of the office has been adversely affected, resulting in inefficiency in service and thereby tarnishing the image of the department in the eye of the general public. These are the reasons why the association has intervened. Now that much water has been flown under the Brahmaputra bridge with regard to the delay in litigation.
You have to cite some other example. We are in Kohima.
Because whatever we consume and spend,
And
all
Brahmaputra
this goes to the
Brahmaputra
river
has at least
Brahmaputra.
five bridges. Which bridge?
As law abiding citizens, we are answerable to the public. This litigation is lingering for the last 14 years. And we were hoping that this will be disposed of at the earliest. During that time, we intervened, hoping that by intervening in the writ petition, it will be disposed of expeditiously as possible. But that was not made possible. That's why I'm referring to the river under the Brahmaputra bridge. Now, with regard to the appointment, the present appellant has been appointed by the PWD department. But posting has been done in the urban development department. Now, if it is on deputation, then there is chances of absorption in the deputation post. But then it was just posted. Therefore, till date, there is no order of absorption of the appellant. in 2004, NPC conducted the recruitment process for the post of assistant town planner. The respondent number 1, as well as the present appellant, they competed. This was strictly done in accordance with the provisions of the service code. This is 2004. And my learned friend was referring to the notifications of the government that roll came into force only in 2008. Whatever may be, that is all. Fact remains that the appellant did not qualify in the exam, and the respondent number 1 qualified in the exam and appointed as assistant town planner on regular basis. Now, I'm just putting one word. A person who has sit for the exam and having failed, whether such a person can be conferred seniority over the one who has passed in the NPC exam. As simple as that. Whether appellant will have a preference over a person who has qualified in the NPC exam. One. Two.
No, an extreme example was given yesterday that even if he had not sat for the exam, will it affect his seniority, the claim for seniority? But worst case, he did not even compete in the exam. He competed, he failed. As per him, it's a wholly irrelevant factor. And even to the extent that he had not even sat for the exams, that should not come into the way of determining the seniority. That is the contention.
Okay.
How do you react to this?
Yes. Then, if we go by that, what is the meaning of conducting the competitive examination? There will be no meaning of conducting the NPC examination. This is the highest recruiting agency in the state who are invested the powers to conduct recruitment, to conduct examination. It is a constitutional provision. And it's not a case that only for a particular department the advertisement was issued. For the whole state advertisement was issued. Selection process conducted, and if it is going to be ignored, what is the meaning of conducting NPC exam? There will be no meaning. That is one. Rule 16. My little friend was saying that the rule came into force in 2008. If there is any rule prior to 2004, and what rule was relevant, let my learned friend show also. This was the rule which was made applicable in the department, and to determine seniority in terms of the service role, this is the provision. Let the appellant show that. But so far as I'm concerned, Lordship, we are governed by the service role. Before enforcement of the service rule of 2004, it was a trap.
Draft
In
rule.
the draft stage, even a draft service rule can be applied during the finalization of the rules, enforcement of the rules. And Rule 16 is very clear with regard to the fixation of seniority, that seniority will be fixed in accordance with the merit list of the NPC. Of course, I made her here note that yesterday when Lordship has put me a pointed query that which side are you in, whether for the appellant or the respondent. I have responded that I'm for neither of them, but I'm defending and protecting the service role. So long as the service role is violated, then where to go? Service role is meant to be applied and enforced. And once that is violated, then there will be no rule of law. Therefore, we want to protect our service conditions are governed by the service rules, and we want to protect this. That is how we are interpreting. Now, Lordship, just for a moment, coming to the redesignation, because a lot of queries have been made by this honorable court. So I would like to clarify on that point. Page Redesignation is at page 187 of appeal memo. My learned friend has also read out this order pattern again. I will just highlight on the relevant portion. It is a short order, so let me read out portion. This is 20th September 2006. This is the redesignation order. Special Lordship Study. The Governor of Nagaland is pleased to redesignate the existing post of Assistant Architect as Assistant Town Planner in the establishment of Urban Development Department plus one so presently held by Srimati Internal Chichu with immediate effect. I would like to rely on the two words, that is presently and with immediate effect. Because the association, we are saying that, look, she was appointed by the PWD department and posted in our department, and she has not been absorbed in the department as one of the employees of the department. Because she has not been absorbed in the department in the cadre. In case of Jeniton, my learned friend has referred to page number 304 and 305 to show the appointment order and absorption order of Jeniton, the first incumbent who is holding the post of the HOD now. He was appointed by a similar order, same order, and posted to the Urban Development Department. During the intervening period, he obtained MURP degree. So department feel it appropriate to absorb him in the department, and he was absorbed in the department. What you will find at page 305 of the appeal memo, and he was absorbed. Let the appellant show even the piece of paper how she has been absorbed like that of Jenitu. There is no order of absorption. So at present she is in a vacuum. Now the redesignation order says presently held by the present appellant. They have probably applied their mind. Presently it will be held by her. Tomorrow it will be held by another person. And the post, by redesignating the post, it is not engraved in a person concerned that this post will remain forever, for all the time to come for this particular purpose. No, it is not earmarked for a particular person. Only the post has been redesignated. Presently it was held by the appellant. Tomorrow it may be held by anybody else. Therefore, by redesignation, how your color will change. I would like to set an example. Today, Gauhati High Court, Gauhati High Court. Tomorrow, if the name is found to be changed, then Gauhati High Court, like that the name of the city. Only the name has been changed, but the functioning of the Gauhati High Court remains the same. Only the name has been changed. A judge may go, a judge may come. It will keep changing from time to time. But the functioning of the High Court will remain the same to maintain the role. Similarly, in the department also, that post which has been redesignated, earlier it was assistant architect, now it is named as assistant town planner. Only the post has been changed, and it is not inbuilt and imbibed with the person concerned. Person may come in, and that was made with immediate effect. It will be effective only from that day. That is the possible reason why the learned single judge has given her seniority, taking into the consideration of humanitarian aspect, that she is serving in the department for a long time without sending her back. So it will be, in the fitness of things, it will be appropriate to grant her seniority from the date of redesignation of the post. That is 20th September 2006. That is the date of redesignation of the post held by the present appellant. And if any retrospective seniority is granted prior to the redesignation, that will also be contrary to law against them. And the appellant is claiming seniority with effect from the date of prior initial appointment, that is 2000. The requirement of education qualification, eligibility criteria for holding the post of assistant town planner is.
Mr. Jamir, the one question will still arise that in the meantime, much development has taken place.
Yes,
The appellant is not holding the post of assistant town planner now.
exactly.
If she was not born in the cadre of assistant town planner, how was she considered and promoted to higher post in the department?
Lordship, it was an interim arrangement by the department because they challenged the rules.
Not only once. Interim arrangement cannot be for
Yes.
twice. Once to the post of as a deputy director, then now joint director. Now she is aspiring to become the director.
That was during the pendency of the litigation. During the pendency of the litigation, promotions were effected. Not before that. Now,
No, that is the question which we are posing to you. If your contention is also endorsed by the department, see, you are not the department. You are espousing the cause on behalf of the association. The department's view may be same as you or may be different. But it is a matter of fact that the appellant has been promoted in the meantime twice,
yes,
not once. It was not an interim management that you become a deputy director, then a joint director, twice. And to effect a promotion, department could have very well said, no, we don't consider her to be in the cadre, to be a member of the cadre. So we are not, she's not within the zone of consideration at all. Department thought it otherwise. There was no direction from this court that you go ahead and consider her case. You, a department on their own volition, considered the parties, they have been promoted. So this question is yours, your basic submission regarding when, from which date the seniority is given. That will consider 2006 or whether it should relate back. But to contend that she was never born into the cadre, that from the subsequent conduct of the department, it may be slightly a matter of debate.
my Lordship, if these kind of practices are allowed, it will be giving it will amount to giving a stamp to violate the service rules. We are governed by the service code. Tomorrow, if this action is not in effect with tomorrow,
Now
The
see,
four-
there's another problem. See, the learned single judge, while allowing the writ petition, had also made certain observation
yes,
on protecting the seniority of the present appellant,
from
which had
29
2006,
2006.
which you also very fairly pointed out right now. Now that observation would mean that in case tomorrow there is a consideration for promotion to the
Next
next
higher
higher
post.
cadre of director,
Correct.
then she'll also come under the zone of consideration. So your basic contention that you want to protect the service rules
Yes.
so that the service rules are followed meticulously and members of the cadres are not put to any prejudice, then you had not put to challenge the
Yes.
earlier, the second part of the judgment.
Because
Neither they have put to challenge.
this,
So that part, I think
Granting of-
that part we did not even consider that whether she is a part of the cadre or not. She is a part of the cadre indirectly. She has come into the cadre and she has been promoted.
the learned single judge has made an observation of granting seniority from 2006.
Correct.
That is with certain background that was given. So long as 2006 is given, still we are agreed. Because without any obstruction order,
No,
Like that of
as
Chinese.
a respondent in the appeal, you can at best support the judgment of the learned single judge. You cannot say it without an independent
Yes.
appeal. That is
I have the challenge.
neither you nor the private respondent, not the writ petitioner.
And I think in the redesignation, is there any condition that you will not carry along with the scale, status, seniority?
My learned friend has referred to the SI Roplal's case.
Hmm.
Out of the 4 criteria, pay scale is the last criterion to be taken into consideration to treat the service whether it is equivalent or not. So there is designation order. Of course, my learned friend was studying his submission. Counsel for the private respondent number 1. He started his submission on the point of redesignation, but ended with something else. But then my learned friend was trying to refer to all the backgrounds. The redesignation has been done at the behest of the appellants. He was trying to show all the documents how it was done. And another aspect which is very important, prior to 2006, the erroneous appointment in the PWD department was not raised by the present appellant. There is not even a piece of paper to show that, look, my appointment in the PWD department was a mistake, and that mistake was corrected. That issue was not raised till she is redesignated on 20th September.
No, we
2006.
raised this question yesterday. He said that yes, I could have raised this issue, but since the issue was taken up by the department, corrected by the department, it ended there, it rested there. Which, however, is the subject matter of challenge in the writ petition. That's a different matter.
It is up to the department. How the department has done, I don't know. But my concern is the service road is to be protected and it should be scrupulously.
Exactly 12:30. Man
I
of,
should-
you're
I
a
should-
man of words.
I should keep my words.
Much. Lordship, just a few points in reply.
Just 10 minutes.
Very well, Madam. First and foremost, the order of redesignation. First and foremost, the
Yes.
order of redesignation. Your, one of you kindly see which department has issued this order of redesignation. Page number 82 of my, page number 23 of my typed copy.
One 187.
Yes, Madam, and page number 23 of my typed copy is clear.
No, it's okay. We can read 187.
Yes, Madam. So, redesignation is by the Department of Planning and Coordination, my lords. If the Works and Housing Department owned my post, the redesignation would have happened by the Department of Planning and by the Department of Works and Housing. That in fact is a contradiction of the entire basis of the arguments advanced by the other side. And the only case which was advanced in the Lip Court was that I am a creature of the Works and Housing Department, and consequently all the other arguments connected with that. Nothing more. This argument about equivalence is being raised for the first time. This,
No, in any case, the subsequent conduct of the department in considering and in fact promoting you
yes, ma'am.
to higher post, I think this puts to rest the factor of whether you are born in the cadre or not.
Yes, ma'am.
That I think is put to
The
rest.
only issue is when.
Now when? That is the question.
That is the only issue.
That of course.
Yes. that is-
They are saying it should be 2006.
Yes.
You say that it should
Because
relate
there's-
back.
Yes.
It should relate back.
Relate back.
Yes.
And there is a difference between absorption and redesignation. And the import, the ramifications of redesignation were known to the writ petitioner. Or should we,
Now, you may also contend that so far as the earlier incumbent is concerned, though there was an order of absorption, for you such absorption is not required because you are redesignated by the department itself.
yes,
Number one, you have been subsequently promoted considering you to be in the cadre of the feeder post.
yes, ma'am.
That is, yes, we'll consider
Yes, ma'am.
the date
Yes, ma'am.
of from where the seniority is to be reckoned.
then the worship, even the Ancient 2, which all of us have read about, there is a process for the decision making process. Worship is a process. And the entire process subsumes into the final act. A Greek proposition, my lord. I don't think it is adhered to the course of law. Now, when the post of assistant architect was redesignated and included in the rules of 2004, published in 2008, the entire process, including the notifications, including the decisions of the PNR, which is something that now stands subsumed in the redesignated post covered by the rules. So the challenge to the notification itself also does not lie anymore. It is only the only question, as I was submitting earlier, yesterday, madam, the only question is, when does it take effect, the redesignation? Okay. And the last point I would like to, Your Lordship, about that paragraph 7,
Paragraph?
paragraph 7, which the writ petitioner was relying upon.
Thirty-seven.
277.
Page
277.
277.
Paragraph 7. Short point I would like to make.
Yes,
but
yes.
going through the language of the affidavit.
Yes.
That with regard to paragraph 11 of the writ petition, the deponent states that the post of assistant architect was requisitioned to the NPSC through. What should be kind of through? It is not by. It was through the NPSC, through the Works and Housing Department. So it was not a post requisitioned by the Works and Housing Department. And this goes to the point I was trying to make, that I was making yesterday about. The requisitions were routed through the Works and Housing Department. The requisitions were drawn up by my department in both the case of the first incumbent as well as my selection process. It was routed through the Department of Works and Housing.
Let us see the notification itself. It will make it clear. 17/1/2000.
71, 2000. Seventy-one 2000 is the appointment order of my appointment order
Yes, that was the reference in paragraph
Yes, sir.
7.
in paragraph 7.
Paragraph 7. Their interpretation we can
Then
check by the actual notification.
for requisition, Your Lordship.
Yes. No. You have just read paragraph 7
Yes, madam.
to contend that it was true.
Yes, and this goes back to the letters written by the department to the NPSC.
No. So this the language employed
Yes,
has
madam.
to be checked with the annexure which has been referred.
Yes, madam.
You just came to the 277, isn't it?
That's what.
Let us read 277 again.
So it says, however, issuing a final order does not mean that the Works and Housing Department requires the right to take an according to the appointment order. This is the appointment order of the
Order.
appellant.
Okay.
But the actual selection process, which was initiated, it begins on page you're referring to yesterday. Petitioner.
Page 230.
Page 303. 303.
Yes, please.
So this is the process which began for the first incumbent. And this requisition was submitted by the Planning and Coordination Department, my department. However, the NPC gave the advice that it should be routed through the Department of Works and Housing. and which resulted in the appointment of the first incumbent, which is at page 309. The same thing in my process, in my case also, Your Lordship.
Okay.
And that will, Your Lordship will see in page 306. 306. This is my process. The
Yes.
requisition went from my department. And then the reply of the NPSC, will find, Your Lordship will find in page 307.
Yes.
And they ask us to route it through the Works and Housing Department.
Yes.
So this is the point I was making yesterday.
Yes. Sir. Yes.
Yes, that's what I'm saying. That is what it is.
Yes.
This is like a Lordship, classical example of assembly saying that Hobo Pala, Hobo is having. This is
No, Your Lordship, just one more point.
very much relevant.
Just one more point, Your Lordship.
There is no Nagami saying of this nature.
As far as
There will be.
as far as the interveners are concerned, Your Lordship, just one, paragraph 24, the learned single judge has held that they have no locus standi.
That is the order of learned single judge only. I have been allowed to intervene by the division bench. And this is what I have referred.
Okay, we are closing this. Third sir. Right. The hearing is concluded. The judgment is reserved. We may not be physically present to deliver the judgment together, but we'll do it online or whatever.
My job.
Yes. Doesn't matter. We'll just resume in 5 minutes because the second half we have to rise early. There are meetings. So whatever is possible till 1 o'clock, then maybe for half an hour in the second half. Or this bench. I don't know my brother. There's a full court meeting also today. At least motions and important admissions will do. Yes,
Your
yes.
Lordship, I beg to mention item 55, Your Lordship, of the hearing days. This is a fixed matter. On last occasion, I was asked to receive instructions, Your Lordship. However, I need to receive instruction that the department has asked me to sort for 1 week's time, Your Lordship.
Who is for the other side?
Lordship.
You grant some time? 56,
Yes,
on a prayer,
55, Your Lordship.
55.
Yes, Your Lordship.
On a prayer made on behalf of the state, further period of 2 weeks is granted to enable seeking of instructions. 55, okay.
Much obliged.
Item 32, Lordship.
Yes,
Hearing, Lordship, if this matter can come up next week, Lordship.
okay. On a prayer made on behalf of, that's for number
I'm for respondent number 8,
8,
999.
9. Matter is adjourned to be listed after a week.
Obliged, Lordship.
Lordship, I beg to mention item on behalf of I, Your Lordship.
Item number 4,
Yes, Lordship.
admission of 2020. Why are they mentioning?
Lordship, the state has filed the opposition only this month, Lordship, on the 5th of May. So only grant us 3 weeks to file our.
On a prayer made on behalf of the petitioner, 3 weeks time is granted to file rejoinder affidavit. Yes,
Mr. Lordship, Lordship, item 57, hearing.
Hmm.
I'm waiting for the paper responding here.
yes.
Lordship, I have other fixed matters, so this matter will be taken up after 3 weeks.
57
Yes, Lordship.
after 2 weeks.
58, Lordship, 58.
58 last matter after 2 weeks.
3 weeks, Lordship. 3 weeks.
Why to 3 weeks? Okay, 3 weeks to 23 matter. You're for the petitioner,
I would have private respondent.
private respondent, number 7. On a prayer made on behalf of the private respondent number 7, matter is adjourned by 3 weeks.
Obliged.
Please, Lordship, my lord, I beg to mention item number 7.
Yes,
Here I'm yet to receive status report. So can allow me 3 weeks time.
you're for the petitioner.
No, I'm for the state. I've taken consent from the opposite party.
Your name, why state names are not reflected? On a prayer made on behalf of the state, matter is adjourned by 2 weeks to enable
Your Lordship,
obtaining,
I'll 3 weeks time.
2 weeks, 22 minutes, 2 weeks to enable obtaining of status report. Registry to reflect GA Nagaland in the cause list.
Much obliged.
Two weeks for what? You need 2 weeks for what? When was the affidavit of opposition filed? Okay, on a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks to file rejoinder affidavit. 2 weeks to enable filing of rejoinder affidavit. Yes,
Yes, Lordship. Lordship, I beg to mention item number 22.
22, yes.
I'm appearing on behalf of Toshi Olongkamar. So Lordship, kindly grant us 2 weeks to file affidavit in reply.
Same order, no? 22. Yes,
Obliged, Lordship.
So, Lordship, Lordship, I beg to mention item 16, Lordship,
16.
16, Lordship, on
Yes.
behalf of more Indian Lordship. Any grant 2 weeks time to file my counter, Lordship.
Government,
Lordship,
government 2 weeks, huh? 3 weeks,
3 weeks, Lordship.
yes. For counter affidavit.
Lordship, I have similar prayer for item number 18, Lordship,
18. You file affidavit,
to file. it,
okay,
Lordship.
3 weeks.
Yes, Lordship. I beg to mention hearing item 29.
29 years.
Lordship, the senior counsel, Mr. Ibn our case, which is possible, kindly let us know.
19 matter, okay. It is submitted that the conducting council is unwell. The matter is accordingly adjourned by 2 weeks.
May I please, Your Lordship,
Conducting service.
may we please
Conducting service for the
mention
petition.
item number,
Just a minute, conducting service for the petition. Yes,
item number 23, Your Lordship,
yes,
23.
yes.
Your Lordship, just yesterday, Your Lordship, I received Parawai's comment, Your Lordship.
Okay, we grant you 3 weeks time.
So
3 weeks time to file the counter. It is submitted that the Parawai's comments have been received only yesterday. And accordingly, the learned State Council has paid for and is granted 3 weeks time to file counter affidavit.
Your Lordship, I also beg to mention item 3.
3 years.
Your Lordship, if the matter can come up next week, Your Lordship.
After a week, government advocate.
I'd like to mention item number 56 also.
Yes,
For petition in this case. also.
yes.
Matter may be listed next week.
56
56.
petitioner after a week.
May I please, madam? Lordship, I beg to mention item number 24.
Hmm.
If 3 weeks time can kindly be granted to me to file my counter affidavit.
For the government,
Yes, madam.
3 weeks. Government, huh? For filing counter affidavit.
I'm deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item 10, with the consent of the other side.
Yes.
Lordship, the standing counsel in this case, Sir Suman Chitia, is an outstation counsel from Gauhati. As such, due to fixed matters at the principal bench, she could not come and appear before Your Lordship. Lordship, may be kindly please.
Well,
note the matter.
tell us a date, we'll fix a date.
Lordship, next date may be fixed on the 4th of July.
4th of July.
Yes, Lordship.
You know what has happened on 4th of July?
No, Your Lordship.
You don't know 4th of July. Born on the 4th of July? No. 4th of July is a very important date for a country. Which country?
Yes.
US. You know about it. So why 4th of July? We will not have on the birthday of US.
Lordship, any date on July.
Have a date in June. We will not. This matter is of 2022.
Yes, Lordship.
We'll fix a date. We'll give you the accommodate you, but not in July.
Last week of June, Lordship.
Tell us a date. We'll fix a date. We'll have it on 25th of June.
Lordship?
25th of June.
Yes, Lordship. Much obliged.
It is submitted that the IT department, income tax.
Yes, Lordship.
Income tax department is represented by the standing counsel who is from Gauhati. And therefore, an accommodation is sought for full stop para. As requested based on 25/6. Yes.
Lordship, there's an interim.
Interim order. Para interim order passed earlier to continue till the next day of listing.
Much obliged.
Please, Your Lordship, I
Yes.
beg to mention item number 19.
19, yes.
Yes, Your Lordship. Kindly grant us 3 weeks time, 2 weeks time to file a reply.
2 weeks or 3 weeks?
2 weeks, Your Lordship.
Have 3 weeks, 23 matter, 3 weeks. Rejoinder, when was the affidavit filed?
Your Lordship, we're filing a reply.
When was the affidavit in opposition filed? No idea.
Your Lordship, it was filed on 18/3/24.
18th, 3 weeks time, huh? For filing rejoinder affidavit. Yes.
Much obliged.
Please, Your Lordship, I beg to mention item number 28.
28, yes.
Kindly this matter may be listed after 2 weeks.
For the petitioner,
Yes, Your Lordship.
18 matter, why 2 weeks? These are old matters.
Yes, Your Lordship.
Have it next week.
Senior, some proceedings will be this next week, Lordship.
Your
Otherwise-
senior was here,
Yes,
he had
yes, next
argued.
week.
He's
Otherwise,
very
let's
much
kindly
here.
take it up today.
No, next week, not 2 weeks.
Yes, Your Lordship.
A prayer for adjournment has been made on behalf of the petitioner, full stop para, considering that this matter is of the year 2018, a short accommodation is granted, directing listing of this matter on Thursday next. Next
Yeah.
Thursday.
A similar prayer for item number 30, Your Lordship.
30.
Yes, Your Lordship.
30 again, same, next Thursday.
Yes, Your Lordship.
Okay.
Your Lordship, I beg to mention item number 34 to 54.
34 to 54.
Yes, Your
Any
Lordship.
other matter remaining in the list? Why don't you say 1 to 54? Okay. Yes.
Your Lordship, can we have this matter on the end of June? Can we fix this matter?
What are these matters? Affidavits exchanged?
Yes.
Will be taken up for admission.
Your Lordship.
Yes, we can fix for admission hearing.
Oh, all the parties have appeared.
Yes.
Pleadings exchanged.
It's in the- Your Lordship is in the hearing list.
Hmm?
It's in the hearing list.
What's in the hearing list?
Yes, Your Lordship.
Okay. Why are you seeking time?
Your Lordship, because there are a lot of matters. to be answered.
Point is one. Matters are lots. Point to be argued is one point. One week. One week. We'll have it next week. Next week. How long will you take?
18 items I altogether.
No, 18 items will not, it's not the matter, it's matter
Yes,
for
Lordship,
us.
I will not take much time.
It's only the
From my
point,
side, I will not take much time.
it's only the point of law.
Yes. Lordship,
What
I
is the
will-
issue about?
Lordship,
What is the issue about?
Lordship, the contempt quarters that were deliberated and contempt were allotted to me. To the petitions.
Your government servants.
Some are government servants, some are not, but it was bought, there was not necessarily an option, but after the survey,
Okay, we'll come back at 2 o'clock.
yes, Lordship.
We'll, whether we grant some time or we hear this.
But the
matter,
issues are very simple, like Lordship.
We will decide. We may
Ah.
grant time also because today we have to rise early. That is the constraint. Otherwise, we'd let us come back
Alright.
at 2 o'clock. Any more mention? Let us at least finish the mentionings.
Lordship, I beg to mention for item number 57.
57,
Yes, Lordship.
yes.
On behalf of H. Selen, Lordship, the counsel for the petitioner has some personal difficulty today. Can you miss the matter after 2 weeks?
2 weeks, on behalf of the petitioner, 2 weeks. Yes,
Lordship, I beg to mention item number 13, Lordship.
1-3, yes.
Lordship, the state is yet to file counter. 13 and 17, I have similar for you.
13 and 17,
Lordship, the state is yet to
on,
file.
on behalf of the state, on a prayer made on behalf of the state, please, Doctor? 3 weeks, 3 weeks. And then 17, you write separately, registry to reflect permanent advocate Nagaland in the court list. Okay, rest of the mentioning at 2, otherwise we will not be able to make it.
Lordship, just one mention, Lordship.
Yes,
I beg to mention item number 9.
9 years,
Lordship, in this case, I filed my affidavit in reply to the counter affidavit filed by the state respondent.
okay.
So if the matter may come up for admission hearing after 3 weeks.
Why 3 weeks? You have filed the pleadings, next week it will come.
I have just filed my reply this morning.
It will come next week.
Lordship, after 3 weeks, Lordship.
You have filed your reply, why do you need time? You seek time for filing reply or pleadings, if pleadings are over,
Lordship, at least 2 weeks time I will give.
why?
Lordship, because similar matters, some of the matters, it appears that some of the matters are pending.
So that's a different prayer. On a prayer made on behalf of the petitioner, matter is adjourned to be listed after 2 weeks. Okay, 2 weeks. Yes, anything?
I beg to mention item number 8.
8 years.
Her affidavit in reply is due to be filed. So I believe 2 weeks time may be granted.
8, you have already made a mention. Reply, they have filed counter affidavit,
Yes, Your Lordship.
3 weeks to file rejoinder on behalf
I
of the
also beg to mention item number 31. I'm for responding number 4. I believe 2 weeks time may be granted
for counter affidavit.
for hearing.
For, oh, this is a hearing matter.
Yes, Your Lordship.
Yeah, for the respondent number 4, no? On a
Yes.
prayer made on behalf of the respondent number 4, matter is adjourned by 2 weeks. Okay, rest of the, after 2 o'clock.
9, 10.
Sound down.
For motion item number 1.
This lordship.
Yes,
My lord, this I is.
for implement.
Yes, implement of.
Yes, madam, what do you say? We allow this, and we have this for main repetition for motion on Monday or whenever day. Main repetition will come up for motion on Monday. All right. Third Swiss Learned Council for this, for the applicant, who by means of this application has paid for implement of the following incumbents as party respondent numbers
4 and 5.
4,
4 and 5.
4 and 5. Number 1 is paragraph 3, personal administrative reforms. Accountant general. Sarah, it appears that such application has been filed pursuant to the observations made by this court in its order dated 21/5/2024, passed in the connected writ petition. Considering that the opposite parties who have been sought to be included are necessary parties in the proceeding, the instant I is allowed. Accordingly, the aforesaid parties are to be implemented as respondent numbers 1 and 2, as respondent numbers 4 and 5 in the writ petition. First of I accordingly stands disposed of. In the main writ petition, you write, by an order passed today, that is so and so, in IA number so and so, the following parties have been added as respondent numbers 4 and 5. The petitioner is accordingly required to file amended cost title. Full stop. The writ petition may be listed for motion immediately thereafter. Yes.
For motion item number 2.
Please, Your Lordship.
Yes.
Lordship, the petitioner here is paying for appointment on land ownership basis.
Third, counsel for the petitioner. The petitioner has put to challenge the appointments of the respondent numbers 9 and 10 and has claimed such appointment on the basis of landowners. Let notice be issued written by 4 weeks. So Learned State Council accepts notice on behalf of respondent numbers 1 to 8. Let extra copies be served upon her by tomorrow. Let steps be taken for service of notice upon the respondent numbers 8, 9, and 10, 9, 10, and 11 by registered post with AD. Steps within 3 working days.
Lordship, there's also an interim period
For
stay of
2023 appointment.
Lordship.
They're working for 4 or 5 months. Why should we stay there? Let them work. If you make out a case, you'll get the appointment. Yes.
Lordship, before we proceed, Lordship, I mentioned item number 4 earlier. However, there's an interim.
Madam, you're late. I will not know what has happened. Maybe it's typed and signed. I think so.
From the supplementary cost list for motion item number 59. Item 59.
We have passed similar orders in this. Same order will be here. When is the next date fixed?
Monday.
Monday. Same order. You will be intending candidates. When was the order? Do you have a copy of the order, madam? Please pass it over. Same order, list along with sales. Have it on Monday. Give an extra copy to learn its state council. He needs to seek instructions. Same Juniper Town Council. All of you aspire to become elected members. फिर both the petition नहीं होगा ना एक ही केस था एक ही दो petition ये जो है two petition one petition this allows every petition. Okay, we'll have it on Monday.
For admission, item number 6.
No, we'll have those matters, the series matters. Because today we'll not have, may not have time. If those matters can be taken up, we'll take it up. Otherwise, we'll go ahead with the other matters. The series matters which were mentioned, we said that we'll take it up at 2 o'clock. Yes. If it's possible, we'll take it up today. If the point involved is a small one, analogous matters. Yes. Not 6. Analogous matters. Item number 34 onwards.
For hearing item number 34 to 54.
May I please, Your Lordship, my sincere apologies for interrupting, Lordship. Lordship, I beg to mention item number 20 and 21, Lordship.
20 and 21.
Lordship. Lordship, we are yet to file our affidavit reply, so kindly grant us 2 more weeks, Lordship, to file our reply.
Okay. On a prayer made on behalf of the petitioner, list after 2 weeks to enable filing of rejoinder affidavit. 20 and 21.
Lordship, there's an interim in item 20. Lordship.
Interim order, if any, stands extended till the next date of this.
Much obliged, Lordship.
May I please, Your Worship?
You're in which item? Which item should we take up first?
Worship, I'm in item number 34.
We take up 34 first.
Yes, yes, Worship.
This is 34.
If I may be allowed to mention. Your Lordship, item number 14.
14, yes.
Yes, Your Lordship, I may be allowed 2 weeks time to file my reply.
You're for the petitioner.
Item number 14.
You're for the petitioner.
Yes, Your Lordship, for my reply.
Okay.
And Your Lordship,
Just a minute.
item number
Just a minute. Let us pass the order.
15.
Madam, let us pass the order first.
Lordship,
Let us pass the order first.
Lordship.
You don't want us to pass the order.
Lordship, obligement.
14. 14. On a prayer made on behalf of the petitioner. List after 3 weeks to enable filing of rejoinder affidavit. Item 14, yes. Yes, next.
Your Lordship, item number 11 and 15, Your Lordship. I'm ready to hear the matter, but the time may not reach. So if it may be come up after 2 weeks.
Let us see if it will be automatically given a date.
Lordship and Lordship, can oblige, my Lord.
I also beg to mention hearing item number 26 and 27.
Yes.
Lordship, we are ready. However, I don't know whether.
If it is left over, then we'll have some other date. Don't worry.
And Your Lordship, with consensus prayer, let it be on Monday.
We'll see. Before we rise, you make a mention.
Okay, okay.
Well, our court master will accommodate. Okay.
May I please, Your Worship?
Yes.
Worship, item number 34.
We'll just try. If it takes long time, then we may not take it up.
Lordship,
If it's a short issue, then we can.
Lordship, may I just in brief before I take
Yes.
your Lordship to the
Yes.
facts? Lordship, the wife of the petitioner was an employee of the government. Wife of the petitioner, my lord. Now she was allotted a quarter on 8/11/2025.
8/11/2025.
2025. Yeah, 2005. Sorry, Lordship. I'm sorry. That is at page 26.
Wife allotted quarter.
Wife allotted quarter, a type for quarter. Under the
She is a government employee.
Yes, Lordship.
With which department?
PWD.
Okay, then what happened?
Then Lordship, this quarter was
Yes.
dilapidated, Lordship, so therefore a survey was made.
This quarter is in Kohima.
Dimapur.
Dimapur.
All these petitioners are from Dimapur in the same locality, Lordship. Earlier, this was a colony for the PWD, but subsequently it has shifted. On 3/11/11, Lordship, which is at page 32 of the petition, a report of the condition of the quarter was made.
Page
32. And therefore, it was given that it's almost in a collapsible condition. Page 32, Lordship. That was page 32.
But why hasn't the government employee come before this court?
No, Lordship, then the husband has come because when the material of these quarters was auctioned, given to me, to the husband.
The quarters were auctioned?
The materials of the quarters.
Okay.
So I
First,
paid,
okay.
the husband paid the money and he got the.
The cause of action is of the husband.
Lordship.
Cause of action is of the husband, the present
Auctioning of the
petitioner.
quarter, yes. Of the material of the quarters.
Okay, 32 is the
32 is the
inspection report.
Yes, Lordship, may I kindly see page 33, that copy. This report was made by the SDO, the executive engineer.
Please read.
Respectfully to state that the undersigned officer in charge has physically verified the building on account of partially collapsed due to wave of cyclone which came on 11/5/2011 during earthquake occurred in Japan. This building was constructed in the year 1968-69 with capital cost of rupees of 14,77,573, which has been neglected many years without any repair. Hence, the building ultimately became collapsible condition at any time and uninhabitable to stay. Secondly, as per the land tenure system in Nagaland, the department could no more purpose for reconstruction as Deputy Commissioner Dimapur has already issued pata bearing number such in favor of occupant Vikazimomi. That is the husband, the petitioner, Vikazimomi. By DC order number such dated 8 July 2011, despite having existing government quarter and before right of condemnation. Therefore, this office authority has got no objection to propose for public auction and thereby put up the survey report for favor of the necessary approval order.
Okay.
Then Lordship may kindly turn to the next page, which is page 34. That copy at 35, Lordship.
35.
Yes, Lordship. When the executive engineer gives the approval to the SDO, Lordship, may I read this letter? And first share with the survey report of the above mentioned quarter duly updated as per your letter number such dated 3rd November 11, 2011. You are directed to dispose of the surface material by observing all late public formalities. Since the matter is natural collapse, you may keep proper records. So this was approved by the executive engineer and communicated to the SDO by this letter dated 4/11/2011.
Yes.
And accordingly, Lordship, at page 36.
Yes.
I was asked to deposit a sum of rupees 2,36,400, which I did.
You had deposited
Yes, Lordship, I have deposited to the department,
2 lakh,
to the PWD
230 lakh, 36,400.
400,
Okay,
and receipt dated 7/11/2011.
yes.
After this, my lord, the order was issued. That is at page 37. Lordship, the type copy is at page 38. My lord, this is office order dated 5th November 2011.
Yes.
Right of condemnation of government quarter number such type at PWD Colony Department. In view of the partial collapse and approval of inspection report by order number such dated 4th November 2011, the undersigned office authority has been ordered to write off the building departmentally and hand over back the salvage material to the applicant. By fulfilling all that other formalities through public auction at approved of depreciated cost of the survey report. The empty plot of land is not a part of the write-off, but confined to the building materials only. Accordingly, Lordship, the materials of the contempt quarter was allotted to me.
Yes.
Then, Lordship, subsequently, apparently there were some complaints made by the department to the then Vigilance Department, Vigilance Commission. Then, pursuant to that, Lordship, the Upalok Ayuktha, after the Upalok Ayuktha, without hearing me in my absence, passed an order. Lordship, may I kindly come to that order? That is a page. Lordship, what has happened? After that, a criminal case was instituted against the SDO as well as the executive engineer. The SDO died during the pendency of the trial, so he could not be tried. He passed away. And the executive engineer who had passed the order was approved, was acquitted. Lordship, may I kindly see that order here? That is at page. Lordship, may I kindly come to the complaint first? That is at page 69.
69.
69. That copy at 70. Lordship, may I read this? This is dated 24th September 2011 and returned to the Deputy Inspector General of Police, Vigilance and Anti-Corruption. And this is by the Government Works and Housing Department. Subject inquiry for rampant condemnation and dismantling of government quarter at Timati. I'm directed to invite a reference on the outside subject and to say that the Department of NPWD Housing has set up a committee to inquire into the matter. The committee has submitted their report to the government. Copies of the report enclosed as per annexure such and such. On thorough examination by government, it is found that the case is serious and needs to be properly investigated so that necessary action can be taken against the defaulter. Therefore, you are requested to inquire into the matter at the earliest. So, accordingly, Lordship, after this investigation was done, and 2 persons were charge sheeted, that is at page 71, Lordship, the judgment by the special court, by the court of the special judge, and Lordship, the SDO died, so he could not be tried, and the executive engineer was tried and was found was
not guilty.
Acquitted. Yes, Lordship, at page 89.
Okay.
Page 89 is the relevant portion.
Okay.
Now, after that, Lordship, what has happened? When the Upalok Ayuktha came about, all those pending cases, Lordship, one of my submissions is that this case was no longer pending before the Vigilance Commission. It had concluded. And when the Upalok Ayuktha came, as per the Act,
The order of acquittal was not put to further challenge.
Then, Lordship, when the Upalok Ayuktha came, he reopened the matter, page 41. Lordship. When the Lok Ayuktha
Page 41.
41. When the Lok Ayuktha was constituted, the Upalok Ayuktha reopened this matter, which was already at finality, page 41, Lordship, and passed this order, which is also impugned in this petition.
41.
Yes, 41. Order dated 19/12/2019. Lordship, may I just read 19/12/2019. in RC case number 2/23.
Yes.
Lordship, may I just read the first page, in the relevant portions. This case has been originated from a letter dated 24/9/13. Lordship, I had already, that is
This is page 69.
Yes, page 69, Lordship. Received from the Under Secretary to the Government of Nagaland, Department of Works and Housing, requiring the State Vigilance Commission, now Lokayukta, to inquire into the matter of rampant condemnation and dismantling of PWD Department quarters at PWD Colony, Dimapur. Accordingly, an FIR was registered against Engineer Sonsu and SDO Sonsu under section such and such. During the course of the investigation, the Nagaland Lokayukta police led by Srimati such and such and her investigation team established that late Kashito SDO, Dimapur, had issued 45 number of right of survey reports against PWD quarters at Dimapur, and Engineer Kahuli, the then EE, had approved the following 42 numbers of survey reports for right of PWD quarters. Sorry, 42 quarters, Malak. And then the next page, Lordship. This act to write off PWD quarters at Dimapur by the STO and EE, Dimapur was in total condemnation of the notification 1, notification banning condemnation, right of a government building, issued on such and such by EE, followed by another notification on 26/3/10. There is another notification issued by the state government on 2019, which is reproduced below. So, Lordship, these are the notifications. Then, Lordship, may kindly come to page 43.
Yes.
Based on the established facts and circumstances of the Lordship, Lordship, may I read from the top? Based on the established facts and circumstances above, the Director of the Vigilance and Anti-Corruption filed charge sheet against Engineer Kahul Sema, then EE, Dimapur under section 409 IPC, read with section 13(1)(c) and section 13(2) of the PC Act 1980. The Honorable Court of the Special Judge Vigilance and TTP, Kohima, by the judgment and order dated 31/19, acquitted accused Engineer Kahul Sema from liability of the case. The operative part of the cost order is reproduced here and below. So now she was acquitted. And the other person, my lord, passed away. She was not tried. Therefore, then my lord, the bottom paragraph, the last paragraph of this page, mere perusal of the Honorable Court order dated 31/19 reveals that the Department of Works and Housing of the state government has not been precluded from taking suitable action to recover loss caused to the government by the two officers named above. Lordship, if you read this order, what is the loss cost? There's no finding as to the loss cost. Lordship, I have not taken it for free. It was not given to me for free. I paid for it. Then Lordship, may kindly come to page 44. Accordingly, the Department of Works and Housing is hereby directed to verify the building yet to be dismantled by the allottees out of the 42 right of buildings mentioned above and cancel the dismantle order issued by them by the then SDO and EE. Lordship, I'm agreed by this portion, just this portion, because the
Page
building 44. 44. Verify, second paragraph, verify the buildings yet to be dismantled by the allottees out of the 42 right of buildings mentioned above and cancel the dismantle order. So therefore, my lord, verify those buildings which are still standing and cancel the dismantling order.
But you said that you have already purchased the property.
Yes, number one.
So how are you connected with this buildings which are yet to be dismantled?
That buildings, they were purchased, they were given, this were allotted before the buildings were not, when the buildings were still standing. They were supposed, they were condemned. They were not going to repair it, so you take it. And so therefore, Lordship, what I did, since my wife was still staying there, repaired the quarter and somehow managed to stay there because I had no other, even I could not stay anywhere. I did not have enough. That was the quarter I was staying. At that point of time, Lordship. Subsequently, the quarter has collapsed, it has been repaired. It's no longer standing right now, Lordship. At that point.
How are you connected with this yet to be dismantled?
Yet to be dismantled.
So you are saying that you are aggrieved by the first paragraph of this page 44.
Yes.
Which directs verification of the buildings yet to be dismantled. These have become infructuous. Buildings are no longer standing there.
What has happened? Lordship, may kindly see. After that, at that point of time, when this orders were issued, after this is direction, Lordship. I'm saying it is disputed. The respondent says that this is just recommendation. Recommendation.
Okay, recommendation.
I'm saying this is a direction. There's a particular specific direction, categorical direction.
Yes.
And now, Lordship, based on this, the government has acted. The department has acted. That is at page So I'm challenging this order, this portion of the order, and another impugned order at page 40.
Well,
Page 40.
40.
Yes, Lordship, may kindly note that I was not a party when this Upalokayukta passed this order. And then page 40 also, Lordship, I was not heard. Page 40, Lordship, this is order dated 17th September 2020. May I read this? In pursuance to the direction of the engineer in chief, letter number such.
This has been issued without hearing you.
Yes, Lordship, without hearing you.
See, so far as the Upala Act is concerned, ideally, an affected party is required to be given hearing.
Yes.
But since it is a recommendation thing, and it's a preliminary kind of an inquiry, discrete kind of a, we may for the time being assume that not giving hearing will not be fatal. But it appears that action has also been taken against you by the government without giving you a
Yes,
hearing.
that is true. Now, Lordship, there's another aspect to it.
You're for whom?
Lordship, I am for local.
Who's for the government? Is this order of September 17th issued without giving him a hearing? That is not proper. We may not even go to the aspect of the legality, illegality of the Lokayukta's order. It's only a recommendation thing. But after that, you should have at least given him a scope.
Lordship, my case also, because the matter has ended, and now it's a recommendation, but they're treating it as a direction. The Upalokayukta continuously wrote to the government, what action have you taken? What action have you taken? And they took it as a direction. It's a recommend. They have only recommending powers.
What about the other cases? Other cases?
Other three cases, my lord. Lordship,
or similar?
No, Lordship.
Based on the same recommendation.
Lordship, yes, based on the same recommendation. Same recommendation.
And orders are different.
Orders are different. But the orders are similar, my lord, in item number 34, except for item number 35, 36, and 37, where my learned friend is representing the petitioners. 34, 35, 36, 37, all the other petitions. I'm representing the petitioners, and the orders are similar. I'm challenging the Upalokayukta as well as.
And your cases are similar. That you have purchased the condemned properties.
Similar. And the order there are two impugned orders. One is of the Upalokayukta, the relevant portion, the portion only, Lordship. And the second one is 17th September 2020, except for the names and the quarters, number of the quarters, the contents of the orders is.
No, but all said and done, you have been contending that page 44.
Yes.
The verification part.
Yes.
Is okay. Local can direct to verify.
And cancel.
And cancel.
That's the part there. And cancel. If they're still standing, cancel them. I lose my right. I'll write that had accurate in 2011. If they're still standing, so Lordship, what has happened? I had acquired those materials when the building was still standing.
Yes.
Almost,
we can come back, but on the principles projected.
Your Lordship.
So far as the consequential order is there, we may not be agreeing upon with that order, but he is also put to challenge the recommendation of the order of the Lokayukta. So
the first challenge is that petitioners, they were not heard. Now, Your Lordship, under section 14 of the Lokayukta Act, Your Lordship, the Lokayukta, for the purpose of investigation, they can collect any materials from any person, Your Lordship. So, except for
it is a kind of investigation.
Yes.
Hearing may not be.
Yes.
It's a discrete.
That is
so to that extent, we may
yes,
agree with you.
Except for directing the petitioner to keep the documents, nothing. Now, Your Lordship.
What about the direction to cancel?
Regarding the direction, Your Lordship, I'm coming to that. Now, on the direction, I consider that Lokayukta cannot give direction. Lokayukta can only recommend.
Correct.
Now, Your Lordship, may I take Your Lordship to page 63 of the writ petition?
63.
Page 63, Your Lordship, this is a type of it.
But tell us one thing on facts. Are those buildings still standing there?
No. So that has to be verified.
Government council?
No longer, Lordship.
No
That,
longer.
that will be subject to verification.
No, no, he is making a statement
Yes.
to record it.
Yes,
If the buildings are
In
not
fact-
standing there, then probably there cannot be a,
Lordship, even the
if the
menswear,
buildings are standing, then matters can be different. Buildings are also
menswear,
not there.
Lokaita has not done any spot verification, so that is why that direction was given to verify.
Verify and
And-
cancel.
Yes. Now, may I take your lordship to page 63? This is a type copy.
Yes,
May I read out?
yes, yes.
Today, with reference to a subject, I'm directed forward herewith with the order dated such and such. This is the impugn
Yes,
order,
yes,
your
yes.
lordship. With regard to rampant condemnation and dismantling of government quarter at Dimapur along with enclosure. You are therefore directed to initiate and take all necessary action as per the recommendation, your lordship. Recommendation. Now, in the order, your lordship, the word directed is used. But the direction to whom it was given, your lordship, they have taken as a recommendation, your lordship. And if at all anyone is aggrieved, it should be the concerned department to whom the direction was given. And the concerned department is not before here, your lordship. And in fact, the petitioner, your lordship, he was not a subject to the investigation. In fact, he's a third party. And whether this petition can be entertained at the instance of a third
But the
party.
consequences faced by him, nobody else.
No, your lordship, not by the recommendation of Lokaita, your lordship.
But if you stop at the recommendation, do nothing, he will not come before the court.
No, recommendation now, it is for the state to whether to take action or not.
Okay, okay,
Lordship.
okay.
And of course, it is for the state to defend.
No, no,
but at least-
we will definitely consider your submission that though the expression direct has been used, it is on the form of a recommendation and the department has also understood as a recommendation.
Your lordship.
That's all.
So, and then recommendation has been made as per section 25 of the Local Act.
But what was the necessity to reopen after 8 years when the matter criminal cases ended up in an acquittal of one of the surviving party? And they were not even accused.
Your lordship. Acquittal of the charged officer, your lordship. It must have brought an end to the criminal proceeding, your
No,
lordship.
criminal proceeding, so far as the petitioner per se is concerned, he may not be a government servant. His wife is a government servant.
Lordship.
So the proceedings under the Anti-Corruption Act, Vigilance that should have been also included the wife of the petitioner and all other government servants.
Yes, your lordship. It is there in the order, your lordship.
So were they charged?
No, to verify and
No, in the criminal case, were they even charged? They were not even charged.
not in the criminal proceeding. Two officers were charged. May I take your lordship to the order
No,
where
I've seen that.
Yeah, where
If-
those officers are involved.
If the matter would have been that they were made accused, but maybe charge sheet not filed against them, or charge sheet filed, acquitted, matter has been no different. Here, they stand in a much better footing.
Lordship, is-
Accepting the petitioner in the first case, the other petitioners appears to be government servants at that point of time.
No, your lordship. So far as the other officer are concerned, in my affidavit, the order, may I take your lordship to the writ petition, page 53,
5-3.
page 53.
Yes.
This is continuation of the order, your lordship. Just there are other instances also, 5-3.
5-3, 53.
5-3, your lordship.
Yes.
Now, the last bottom part, in bold it is this, illegal regularization. Lordship has got it.
Yes.
Illegal regularization, settlement, extension order issued by Srimati such and such, NCS, there is Nagaland Civil Service while serving as returning revenue officer, RO Dimapur without the knowledge of DC Dimapur. Now, your lordship. Now, similarly, there are also others. Page 45. Pattern number, page 45, your lordship, top, irregular issue of pattern, regularization of land, extension and mutation of pattern in the period by the office of the DC Dimapur. Now, what I would like to impress upon your lordship is that Now, these things has been done in violation of the notification issued by the state government, Your Worship. Now, whether any disciplinary proceeding can be initiated against them, those things, what Lokata recommended was,
Yesterday, you were impressed, you were trying to show to the court or rather show the statutory provision of limitation.
Lordship,
So far as action by the Lokaयुক্ta is concerned.
Lordship,
See the regularization dates.
once the complaint is.
When was the complaint lodged?
No, Your Lordship, that complaint was, that letter, Your Lordship, which has been referred in the first page of the order.
Yes.
Page 41, 24/9/13.
That was not addressed to the Lokaयुক্ta.
Lordship?
That was not addressed to the Lokaयुক্ta. Lokaयुcta was not even there at that point
No,
of time.
that was when Vigilance Commission was there.
Yes.
So Vigilance.
That is what we're trying to extract from you.
Yes.
This letter, when it was originating, there was no Lokaयुcta.
No, Your Lordship, may I take Your Lordship to. Section 36, Your Lordship.
Yes.
Subsection 3.
Yes.
All inquiries and investigation and
Section?
other 36.
Yes.
Subsection 3.
Just a minute, please. Yes.
My lord has got it.
Mm.
Subsection. All inquiries and investigation and other disciplinary proceeding pending before the Nagaland State Vigilance Commission and which has not been disposed of shall stand transferred to and be continued by
Yes.
Lokata as if they were commenced.
Was it
before him
pending?
Under.
Was it pending?
Yes, Your Lordship. Now, criminal proceeding, those charge officers, they were acquitted, but then no report was submitted under section 25 of the Lokata Act. Your Lordship, may kindly see, when will the investigation come to an end? On submission of report. Section 25 provides that.
See, this act came into being when?
Yes.
2017.
In fact, 2018.
18. So this complaint was of 2013.
Yes.
Was at a time when there was no Lokayukta.
Yes. And
Now,
by virtue of.
There is a provision, you said at page section 36(3), enquiries and investigation which were pending before the State Vigilance Commission would automatically be looked after by the Lokayukta. First, yes, even though the Lokayukta at 2013 was not existing, it has to be a position that is as on the date when the Lokayukta had issued this notice, there was this complaint pending. Complaint had culminated in the criminal case, acquitted, matter is over.
In my respectful submission, Your Lordship, proceeding before criminal court, special judge is different. In my respectful submission, subject to Your Lordship's satisfaction, Your Lordship.
No, then you tell us. We may accept your submission. Why not? But you tell us how does a complaint of this nature at page 69 comes to an end? When?
With the submission of the report. Once,
by whom?
By the local.
No, not now. Before, if suppose this act was not even incorporated, when will this 2013 complaint come to an end?
That will be as per the Vigilance Commission.
Yes, tell us, show us that it was kept pending
and
the criminal case was not the culmination.
No, it is not the case of the petitioner that Vigilance has not submitted the report.
No, we are considering. See, the complaint was registered. Thereafter, criminal case was lodged against a particular officers, whether they have died or acquitted, that's a different matter. They were not proceeded against. They are not proceeded against.
No.
Suddenly, the Lokayukta in 2000, after its incorporation in 2018, then it issues this, passes this order.
I leave it to your lordship.
Maybe at that point of time, there was no work.
No. But my only this thing is that I have raised preliminary objection, your lordship.
Okay. Okay. Will you write? What are the other cases? Similar? But is it connected to purchasing of salvage properties? Same order.
Same.
Okay. Okay.
These are in two parts. The order, your lordship, may I take your lordship to my affidavit? So first part relates to rampant condemnation of government quarter. And second part relates to regularization of allotment and regularization of the land. So my learned friend, he is representing three petition, which relates to regularization of land.
Can you give a list in which case you are there and in which case you are there? Please write it in the list. Give it to secretary.
Lordship, just one more clarification.
Yes.
Lordship, the Upaloka says that it's a recommendation and they have referred to a letter dated 26 at page 26/5/2020 at page 63 to show that it's a recommendation, Lordship.
Yes.
Lordship may also peruse certain letters and the affidavit of the state government to show which I'm relying on this letter and the statement made in the affidavit that it was a direction and it has been taken as a direction. Lordship may kindly note those page numbers. Lordship. Order dated 19/12/19 is one.
Where? Page?
Lordship, page 41. Lordship, that I have already, page 41.
41, yes. Oh, that is the order of the local.
Yes, that is the order. Lordship has seen that. And then Lordship may kindly go to page 40. If you read the impugn order, page 40.
40.
17/11/2020. In compliance to the direction. In compliance to the direction. Fourth line, 1, 2, 3, 4, fifth line. Fifth line. Fifth line. In compliance to the direction of the honorable fellow. Then Lordship may Lordship may kindly come to page 61, man. A letter dated 15/5/2020. Page 61, type copy at page 62, Lordship. So this is a letter written by the Inspector General of Police of the Nagaland Lokoyukta. And writes to the department, Lordship. May I read the relevant portion? I have the honor to invite reference to the above subject and forward herewith the order passed by the Honorable Upaloka White dated such and such, and to direct your department to verify the building and to be dismantled by the allottees of the 42 right of buildings mentioned in the order and cancel the dismantling order. So direction order again.
What is the date of this?
This is Lordship 15.
Where do you get?
2020.
Where do you get the date?
Lordship page 61 at the bottom.
In 5.
Handwritten, Lordship. And there's one more, Lordship.
Yes.
Lordship at page 65. Type copy at page 66, Lordship. A letter dated 28/2020 by the Lokoyukta again to the department, Lordship.
Yes.
May I just read the relevant portion? I have the honor to invite reference to the above subject and also to refer this organization's letter of even date that is 15/5/2020, and to state that as per the order passed by the Honorable Upalabha by 19/12/2029, it was requested to direct you, your department, to verify that buildings yet to be dismantled by the allotee of the 42 right of buildings mentioned in the order and cancel the dismantling. So again, directed.
No, this is not a direction.
It's direction. Then Lord.
This is not a direction.
Oh,
This is only a reminder of the earlier direction. Direction, yes, first order, but these subsequent orders are not direction for cancellation. They are only reminding that there was a direction for cancellation. What is your compliance? That is the.
Then, my lord, then
Where is the affidavit you want?
affidavit.
Yes.
Lordship may kindly come to the affidavit of the state. 1, 2, 3, 4, 5, 4, 6, and 7.
Yes, page.
8, page 4, Lordship. Married 1, 2, 3, 4, 5, 6.
Yes, page 4.
Page 4, Lordship. Married from on receipt, my lord. Married from right in the middle. On receipt of the complaint letter.
Just a minute. Yes.
Lordship responded.
Yes, yes.
On receipt of the complaint letter dated 24/9/13, a thorough investigation was conducted by the State Vigilance Department, which is now the Lok Ayukta, and basing on the finding that the act of right of PWD quarters at Dimapur by the SDO and the EE Dimapur was in total contravention of notification banning condemnation right of government buildings, the Honorable Upper Lok Ayukta passed order dated 19/12/19 directing the Department of Work and Housing to verify the buildings yet to be dismantled by the allottees and cancel the dismantle order issued by the then SDO and EE Dimapur. As per the order dated 19/12/2099 of the Honorable Upper Lok Ayukta, the Government of Nagaland, Office of the Chief Engineer, has passed the order dated 17/9/2020, whereby the right of condemnation of government quarter issued by the SDO, PWD number such and such, Dimapur, in favor of the petitioner was cancelled with immediate. So clear, my lord. The direction came from the Upper Lok Ayukta, and therefore we cancel it. And Lordship, the Upper Lok Ayukta has said that yes, exercise these powers under page 60, Lordship.
Is
Page 60.
of the repetition.
Yeah, of the repetition, Lordship.
60.
Page 60. Then
Yes.
Lordship, at page 60, the first line, my lord,
Yes.
for the information of all concerned, section 25(3) and 4 of the Nagaland Lok Ayukta Act 2017 is reproduced here below, and it's reproduced the section, and based on this, he has acted. He has passed his direction based on these provisions. Now, Lordship, this is recommendation, and Lordship, this honorable court has held.
No, there's a fair.
Yes, there's a judgment also, Lordship.
Considering that it's a recommendation power.
Lordship, then not required, my lord. There's a judgment based on of this honorable court.
You can place it.
Lordship, paragraph 11 paragraph will be, Lordship, paragraph 8 to 12.
Eight to 12.
8 to 12. And Lordship is well aware that yet, just for my satisfaction, the validity order of the order has to be judged by the contents of the order. So here the Apollo order and the European order has to be judged by the contents of the order, whether it's a direction or recommendation. So
That part is considered.
no, they are saying it's recommendation, but if you read the order, it's not recommendation.
He's also said that it's a recommendatory body. It's not a direction.
Yes, but the
How
European
the
order-
state has understood will record it. Don't
Yes,
worry.
Lordship. Then, Lordship, I need not give the citations and principle of natural justice. Lordship. Violation of principle of natural justice. And Lordship,
On PNJ, do you have any citations?
principle of natural
Violation of principle of
Yes, Lordship.
justice, which one?
Lordship, may kindly take the right of 1993 3 SCC. Oh, Lordship.
Yes.
So Lordship, no cases were pending. It had culminated, yet, and Upaloka can only take up pending matters of the Vigilance Commission, yet they took up this case. Lordship, that's my case.
Okay. Please give a small list who is appearing for whom.
Lordship, I will do. Will do.
Your Lordship, to save time, let me just refer to paragraph 3, 4, and 10 of my affidavit.
Okay.
My affidavit.
Regarding
On 3, 4 regarding I have read on preliminary objection on maintainability.
Okay.
That is this thing. And then the facts, how it started, little background, paragraph 3, 4, and 10. And your Lordship, regarding I've given a compilation. I'll be just referring to one case, your Lordship. Case number 1. Is by the
Regarding?
Honorable High Court of Jharkhand.
regarding
Where here also, your Lordship, a direction was given. But instead of remanding the matter back to Lokata, the court itself has in excess of under 226. Yes, instead of direction, the word was modified to recommendation. That is, and then since I'm relying on the order passed by another High Court, your Lordship, case number 2, that
persuasive value.
your Lordship,
Doesn't-
your Lordship.
What's the submission given by my friend in other cases concerning with the law? Speak of the Lokayukta Act. As convicted by my own friend. And the stand taken by the Lokayukta, that piercing is in communication. We are also saying that it is in order, not in communication. Or we can assume as in order, my lord, not a recommendation, because section 2 of the Lokayukta Act, Nagaland, it's about definition. If you know.
No, on that part of direction and recommendation, you did not advance any further arguments. On facts, if it's slightly different, you can apprise this court. Otherwise, under recommendation
Yes,
direction.
in this 3 cases.
Which are those 3 cases? Item numbers?
35, 36, and 37.
Please note, make a note. 35, 36, 37. And the orders passed by the government are different. Same order by the government.
Yes. So,
And-
order dated 19/12/2019. That is the Opaloka.
That is the same order. That has to be the same. But what about the order passed by the government?
No, that's not the fake name, my God. That is not in my case.
Then what is there in your case then?
Here, my land patta, as per the order dated 19/12/2019, issued by the Opaloka Yukta, the land and building where I was residing after purchasing the year 1990 and onward.
But while writing off, the movable property was not, it was not within the writing of order. It was only pertaining to the salvage property, not the land.
Yes.
How did you purchase the land?
Land was
Allotted.
allotted and initially.
Something serious has happened.
Worship is public interest involved, your Lordship.
But here, since.
Building gone, land gone, government. And it's not 1, 2 quarters.
Here, my lord.
You have been successful in dragging the matter, so maybe you may not be affected now, but something serious had happened.
There might be, my lord. There might be, but here, whatever the notification relied by the Opaloka Yukta, as well as relied by the.
Where is the cancellation order of your land allotment?
It is only a show cause notice. They're challenging show
So-
cause notice.
The issue a show cause notice to me for cancellation.
Oh, yeah, you have been given a chance.
Yeah, so
So principles of natural justice may not, isn't followed so far your cases are concerned.
That's why, my lord. The show cause was issued by the deputy commissioner, who is also a respondent in the case. Basing on the order passed by the
But Upalakra, even if we accept your submission, that it is recommendatory in nature, they have followed the recommendation issued a show cause, what is the wrong?
No, my lord, here, why I was also supposed to emphasize on the recommendation. If we are to take into consideration of the meaning of the recommendation, we have to go to definition under section 2 of the 155. That's what I would like to impress upon you. Because section 2, it is very clear. Governor is neutral.
I think we'll segregate your three matters. 35, 36, 37 cannot come within the hearing of these matters. You are trying to preempt an action. Show cause has been given, you submit your show cause, let us see.
Yes, we have
It cannot
submitted.
be even matured. Have you submitted?
Yes.
Then what is the status?
No, they have not taken any steps also.
Stay is there. Stay is there. Is there any interim order?
Yes.
That is why. We will not vacate the interim order, but we'll decide in details your cases. The other cases will dispose of, okay? Okay, we'll,
Next year A, Lordship. Inadvertently, Lordship, I have annexed
which annexure?
and
In which document?
WPC number 15. I'd like to make a- Inadvertently, I
Who
have.
is it?
WPC number, please.
WPC 2 of 3.
No.
Three, we are not. State Council, this matter, you can place it on the next date. We are not taking up those matters. Okay. Okay. Any matters where interim order needs to be extended, otherwise we'll rise, we'll have the judgment, we have a meeting also. We'll have the judgment on today's date itself, okay? We'll dictate in the chambers.
Please. Okay.
Any matter where interim order is still today, which needs to be extended? No. Any urgent matters where orders needs to be passed? Jamit, do you have a better copy of the Lokayukta Act? Yesterday you had given a better copy. This is slightly confusing.
Lordship, may
No, this has got
this. Lordship, may
the,
I take this?
okay. No, better copy means the actual copy. Here, it has got the orders of the CM and all. We don't need. I think this will be better. It's okay. So yesterday you had given a different. Different. Doesn't matter. This is-
Of life. My lord, hearing item number 26. Actually, that is fixed today, but if.
So court master will give a date of your convenience. Don't worry. Okay. All matters where you need dates, court master please give dates. Okay.